James, and they won't start their audio. Okay, on the record, in the matter of the people of the state of Michigan versus Mashawn Maddock, file number 23-02218 FY, council appearance.
Kayla Crino, appearing on behalf of the people.
Good morning, Your Honor. Attorney Nicholas Somberg, on behalf of Mashawn Maddock.
Okay, today's the date and time set for a preliminary examination. I'm first going to address a motion that was filed by the defense. It's a motion for discharge. And in the interest of time, I did review both the motion and the attachment and the response. I'm still struggling with the defense counsel's position as to where the authority is supposed to come from for the district court to dismiss this case for the reasons that you're asking the court to discharge.
Your Honor, I would rely on points I made in my brief,
Which are
being that the Attorney General's public statements basically conceding that Maddock was somebody who was brainwashed, had no intent to defraud or deceive anybody, and that she couldn't, as a matter of fact, take a plea if she wanted to, because she truly believed that Donald Trump won the election, negates their entire case that this is any sort of fraud or forgery or election fraud.
what legal authority are you relying on for the district court to dismiss a felony?
That the Attorney General being the highest prosecutor in the state of Michigan, that by her own statements, that first there's rules of ethics, there's rules of ethics that she should not be bringing a case in which she knows has no merit, and that is cited in my brief, Your Honor.
Do you regularly practice criminal law?
Yes, sir.
Okay, so do you know what the purpose of a preliminary examination is?
Yes, sir.
What is the purpose?
That was probably wrong.
And the jurisdictions before the district court for that purpose, correct? A motion to dismiss because of any other evidence, which is not currently before the court. You're giving me a statement that's not before the court. That's not evidence for the court to consider. What legal authority? Legal authority is not your opinion, or you telling me something that you believe could be some damaging evidence to the prosecution's case. Legal authority will be a court rule and or statute that I can rely on to dismiss this case. And you've provided me with none. So for that reason, your motion is denied. Thank you.
Thank you, Your Honor.
On the record, in the matter of the people of the state of Michigan versus Kathleen Burden, file number 23-02209 FY. Appearance, please.
Kayla Crino, appearing on behalf of the people.
Good morning, Your Honor. George Danini and Garrett Koger on behalf of Ms. Burden, who is in the courtroom.
Thank you. Similar to the motion just addressed by the court, this is a motion filed by the defense for the district court to discharge this case. I need some legal authority.
Yes, Your Honor. What we were hoping is that we styled it as a motion for discharge. I don't have it in front of me because we were planning on arguing at the close of the proofs. We think that the proofs where we are going to be establishing, at least we believe, lack of criminal intent will help to supplement the motion that we filed. So what I asked from the last time we were here together, at least on Zoom, was that we do it at the conclusion of the preliminary exam, which is scheduled to sum up tomorrow, hopefully.
Okay, so you want me to reserve your motion until the end of?
Yes, Your Honor.
Okay, I'll do that.
Thank you.
Okay, and any other preliminary matters before we begin? I don't know if we have all the defendants here. I have one, is this two? No. These AGs, all the AGs, okay, 5 AGs, okay. Who do we have here? That's two. You're not near Mike. If you're not near Mike, I need you to come to where there is a mic, because if you get objection or anything back there, it's hard for us to pick up, and I know we're limited on space in this courtroom, but. Okay, who's in this first row? Are these any defendants?
Oh, okay.
Okay, so nobody's, where's your attorney?
So the woman on the far left is my client Kathleen Burke.
Okay, who are the other two people that raised their hand? What's your name, sir?
Ken Thompson, I'm waiting for my attorney to show up. Dave Gilbert.
What's your last name? Kenneth Thompson, your attorney's not here?
I don't see him yet.
Okay,
I'm surprised, Your Honor.
okay, that's your client? The lady on the end, sir?
Yes, sir.
Okay, we can pull a chair so she can sit next to you.
Your Honor, I'm okay with her sitting there.
You're okay with her sitting there? Okay,
If, as long as the court will indulge, if I need to talk to her, I can slide over there.
well,
I'm willing to move.
I was gonna say, she should probably move to behind you.
That'd be great.
We're not in a space where we can just be sliding
Of
around
course. That's great. Thank you.
in here without you obviously encroaching upon the prosecutor's space. Okay, and then your client, sir, is your client close to you? Okay, very good. And then, of course, I think that your client next, we don't know where your attorney is,
Not yet, Your Honor.
which is not good. And then other attorneys.
Yes, Your Honor. George Brown, I represent Mary Ann Henry, who sits right here.
Okay, is there a mic you said that would pick up in there?
The mic, only mics are at these two tables, but we can hear the first row people and then the juror box, so they can come sit over here and I can pick them up on that mic too.
Okay, what's your preference? To sit next to your client there, or you and your client can go to the jury box?
Is there microphones back there, Your Honor?
There's one in the jury box.
The jury box it is.
Okay, sounds good. Did you want your client to accompany you, or do you?
Yes.
Okay, your client should accompany you. Okay, and Mr. Silverthorne, where's your client?
Michelle Lyman, she's raising her hand. She's in a walking chair and she's got a cast on her leg. So
Okay. Oh,
she can remain there or we can go wherever you want.
if you're okay with her remaining there, that's fine. Just where are you gonna be?
I can be wherever the microphone is.
You can either be in the front row or you can pull up a chair. Someone's gonna have to pull up a chair next to these two. There's gonna be one person on the kitty corner here. And then you can either be in the first row or there.
First row is fine.
Okay, that's fine. Ma'am, on the end, what's your name? Okay, your attorney is here. Okay, very good. So you're gonna be there. So
If I could sit here, that'd be great.
okay, we'll get your chair. Okay, sounds good. Everybody is in some level of proximity to their attorneys, is that correct? Okay, to the best that we can get them. And then we don't know where Attorney Gilbert is.
I believe he's going to call the courtroom in Carolyn. He's telling me, Your Honor. He's not here.
Any other preliminary matters before we call our first witness? Okay, there has not been a sequestration request. I am going to put one in place. So are there any witnesses in the courtroom or potential witnesses?
The only potential witness, Your Honor, is the officer in charge of the investigation, Special Agent Howard Shaw. I would ask for an exception for him, please.
That's typical. There would be an exception for an officer that's part of the investigation. That will be granted. Any other witnesses need to be sequestered. And unless there are any preliminary matters lingering, Madam AG, you can call your first witness.
Which I just wanted to, before we begin, put my appearance on record.
Oh, please do.
Paul Stavlin, appearing on behalf of the National, will be seated to my left. Thank you.
Okay, any other defense counsel appearances that have not been placed on the record? I guess I should officially call each case. People of the state of Michigan versus Deshaun Maddock, file number 23-02218 FY. Council appearance.
Good morning, LaDonna Logan on behalf of the people.
Good morning, Your Honor. Nicholas Somberg, on behalf of Michelle Maddox.
People of the state of Michigan versus Kathleen Burden, file number 23-02209 FY. Council appearance.
Good morning, LaDonna Logan on behalf of the people.
And good morning, Your Honor. Again, George Denny and Garrett Koger on behalf of Kathleen Burden, who is also in the court.
People of the state of Michigan versus Amy Fascinello, file number 23-02211. Council appearance.
Good morning, LaDonna Logan on behalf of the people.
And good morning again, Your Honor. Paul Stablin appearing on behalf and with Ms. Fascinello, who's seated to my left.
People of the state of Michigan versus John Earl Haggard, file number 23-02214. Council appearance.
Good morning, Your Honor. Mary Chartier on behalf of John Haggard, who is seated to my right.
Good morning, Your Honor. Kurt E. Cross on behalf of Mr. Haggard, who is also seated to my right.
And LaDonna Logan on behalf of the people.
People of the state of Michigan versus Mary Ann Henry, file number 23-02215. Council appearance.
Good morning, LaDonna Logan on behalf of the people.
And good morning, Your Honor. George Brown on behalf of the defendant.
People of the state of Michigan versus Michelle Lundgren, file number 23-02217. Council appearance.
Good morning, Your Honor. Dwayne Sullivan from the Office of Public Defender on behalf of Michelle Lundgren, who is seated in the far right corner behind me.
And LaDonna Logan on behalf of the people.
And counsel on behalf of Kenneth Thomas still has not appeared. Is that correct? Okay.
Pardon?
I was calling your counsel, but I don't see them here. So we're going to proceed without your matter at this time, and we'll address that whenever your attorney appears. Okay. Any other preliminary matters we call the first witness?
I don't believe so. With that, Your Honor, the people will call Captain Darren Green as our first witness.
Your Honor,
Yes.
I'm speaking with Mr. Thompson here. This is George Brown, who represents Mary Ann Henry. He's communicated with me that his attorney, Mr. Gilbert, has got a medical emergency. Through text, Mr. Gilbert has asked that somebody communicate that.
Okay. You're free to stay or leave. I'm just going to reset you to the next group of cases because I don't have your attorney here to
I
address it.
understand, I appreciate it.
Okay.
I apologize for this.
It's not, it's nothing you could do about that, but thank you.
Thank you very much. Thank you, sir.
Thank you.
Is this your witness?
Yes.
Okay, you can come here. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
I do.
You can have a seat. Okay, can you state your first, last name and spell them both?
Sure. My first name is Darren, Darren. My last name is Green, Green.
You can proceed, counsel.
Thank you. Good morning, sir.
Morning.
Could you please state your name
Yeah, Captain Darren Green
and where you work, sir?
for the Michigan State Police.
And how long have you worked for the Michigan State Police?
A little over 23 years.
On December 14th, 2020, were you on duty?
Yes.
And what was your assignment on that day?
I was the first lieutenant in charge of state security operations, and part of that umbrella was physical security of the Michigan Capitol building, the exterior and interior common areas of the Michigan Capitol building.
And were you given any particular directives on that day?
Yes. The Capitol was, for all intents and purposes, closed for business, other than the electoral college voting for the confirmation of electoral votes for the president from the vote in Michigan. And other than that, the Capitol building was closed for business that day.
Were you given a list of who was allowed in the building?
Yes, I didn't have the list, but I was told via radio that the 16 people who were there to vote for the electoral college had been checked in and were present inside the Senate chambers, and that no other people for the electoral college were to be allowed into the Capitol building.
And while you were part of the security of the Capitol building, did there come a point in time when another group tried to enter the Capitol building?
Yes.
Do you know about what time that was?
I don't recall the exact time, no.
Do you know what entrance the group tried to enter?
Yes, it would have been the north annex. It's the ground floor of the Capitol building on the north side where a lot of the dignitaries will come and go from the Capitol building.
And how did the fact that this group was trying to enter the Capitol building come to your attention?
I was on the first floor of the Capitol, and one of my officers that was assigned to the north annex called me on the radio and said that there was 2 state representatives and some guests of theirs that were at the north annex that were trying to get into the Capitol building. So from that radio traffic, I went downstairs to the ground floor and proceeded to the north annex.
And did you actually speak with the group that was trying to come into the building?
I did.
And what did you tell them?
I told them that the people that were on the list that had been granted permission to come into the Capitol that day to participate in the electoral college vote had already arrived at the Capitol, were inside, and that the Capitol was closed for business and they were not going to be allowed in.
And when you told the group that the electors were already inside, did the group say anything in particular?
Objection. First of all, calls for a hearsay. And second of all, the question posed is saying what the group said without identifying any particular speaker, so it's impossible to understand who said.
I'll rephrase. At any point in time, do you know how long your interaction was with the group?
Maybe a minute or 2 at the most.
Did you become aware that that interaction actually was recorded?
I wasn't aware of it at the time, but I was after the fact.
Okay.
I saw it on the internet.
Have you seen the recording?
I have.
Okay. And did you recognize yourself in that recording?
I did.
Permission to approach, Your Honor?
Yes.
Oh, Captain Green, I'm showing you just a still photo. Do you recognize this still photo?
I do.
Are you able to tell us whether or not that is from the video that you saw of the December 14th, 2020 interaction?
I mean, I can't say for sure, but it looks like the same angle and the same setting and everything like that, yeah, so it sure does look like, yeah,
Do you see yourself in that photo?
I do.
Lorna, I would ask the permission to be able to share my screen with the court.
Yeah, permission.
And Judge, just so I understand the logistics, while she's securing that up, are we gonna be seeing it here? How do we?
You'll see it up there.
Okay, thank you.
Yeah. For purposes of the record, People's Proposed Exhibit 10 is currently displayed. It is paused so that we can see the first frame. Captain Darren, do you recognize that video?
I do.
And where do you recognize it from?
The internet, and news outlets and stuff.
And did it record your interaction with the group that was trying to enter the Capitol building on December 14th, 2020?
Yes.
People would move for the admission of People's Proposed Exhibit 10.
Any objections to People's 10?
Judge, I have an objection to any of the statements made by anyone other than the witness, because those would be hearsay if they're being admitted for the truth of the matter asserted, which I believe that they probably are. And so the statements of those other witnesses would be hearsay, so they're not admissible. Obviously, whatever Captain says on there is fine, because he's here to be cross-examined, but we can't cross-examine the defendants and the other people that are on the video.
Do you want to respond to the objection?
Well, one, this is a conspiracy case, and the first thing that the people have to do is establish membership of the group. And any statements of that group in furtherance of the conspiracy are admissible against one and all. And the court can accept those statements out of order as long as the people establish that, one, there was a conspiracy and that the defendants were members.
Your Honor. Oh, go ahead.
Go ahead, no, go ahead.
Thank you. I join in the objection. I also join in the objection, quite frankly, of Captain Green's statements, even though he is here to be cross-examined, they are out of court statements, I believe, being admitted for the truth of the matter asserted. As for co-conspirators hearsay statements, we can't cross-examine any of the defendants, so that does implicate Mr. Haggard's rights. But also, it's my understanding there are people on this video who so far have not been charged as conspirators, one of them being a lawyer who, again, is not one of the 16. Thank you.
Your Honor, we also join, other than,
I just need you to state your name for the record.
sorry, George Brown representing Ms. Henry. We join in the objection. As far as I understand, there's not been any identification about any of the other people in the video. We don't even know who they are.
Okay. And so what is the purpose that this video is being admitted for?
Your Honor, it's honestly the best evidence of the interaction. And to respond to the objections, when it comes to conspiracy, all the members don't have to be charged to be established as members. And they can be established as members either by their statements or their actions. I think, excuse me. That being said, this video is very good evidence of most of the members of this conspiracy. It's not even all of the members, but as this court knows with the conspiracy law, not all members have to know what the others are doing. They just have to agree to commit the illegal act and act in furtherance of it. So whether all of the defendants are in this video doesn't mean that it doesn't get admitted. I think this is a piece of the larger conspiracy puzzle, and it shows the ultimate act of trying to publish a forged document, which we have not gotten to yet, on December 14, 2020.
Okay, so I don't have any idea what's gonna be shown on this video. All I see now is a officer, which I'm assuming is this same officer that's here, but I don't know that yet. And my understanding is this is going to demonstrate a conversation or interaction with some people or parties that may not have been charged.
Some of the members in the video have not been charged.
Okay, and is it your intent to have this witness identify some of these witnesses as you play this, or?
No, I
Okay.
intend to play the video just to show the court the interaction of the attempt to enter, but there will be later witnesses down the line who can identify members in the video, as well as I believe there is an attorney who identifies himself in the video.
Okay, so this is,
An uncharged member,
so this is to show essentially what this witness
just testified to.
just testified to. Okay, as it relates to, you were gonna stand up and say something else, I'm sorry.
Yes, Judge, if the prosecution is relying on the MRA 801 D2E, which is the hearsay exception, they have to establish that there's a conspiracy first before any statements on the co-conspirators. They have to establish that the declarants are members of that conspiracy. All we know right now is that this captain was there that day, and this is a video of his interaction with some people. It not established anything that could lay any proper foundation for the admission of hearsay statements.
That's it, yes, you can respond.
The testimony of the witness is that a group who was not on the list to be admitted tried to enter. So you know that they are acting in concert. We know that there is a group activity happening. The membership can be established later, and the court can hold the statements in advance until membership is established. As the court knows, each member has to be established as, each defendant has to be established independently as a member. So the proofs may be taken out of order, and the court can assess in the totality of the circumstances whether or not this video should be used against one or all the defendants, but establishing that there is a group acting in concert on December 14, 2020 shows that there is at least the groundwork for a conspiracy.
Connor,
Yes,
I'm going to join my colleagues in the objection to the statement. It seemed that it
I need your,
William Silver on behalf of.
Thank you.
It would seem that the objections related to hearsay are on point and the statement should not come in. The fact, however, of the presence of persons would be all, I think that would be able to come in on this. And so if the court intends to play the video, I would indicate that the video should be played without sound. Because you can still visually identify a person being there, and then later on, just by statements, establish whether there's a conspiracy.
Your Honor, Nicholas Summary, Beth and Sean Maddock. I'd like to join my colleagues in any objections, also raise the objection just based on relevancy. They're not charged with attempting to enter the Capitol. They're not charged any sort of trespassing crime. They're charged with conspiracy, uttering and publishing election fraud and forgery. This is not a video of any sort of meeting or signing or anything. I say this is prejudicial and irrelevant.
Well, may I respond to that? So
Yes,
while I still have it.
I understand.
The defendants are charged with uttering and publishing requires a publishing of a document. And the people will put forth to the court as an offer of proof that this video shows an attempt to publish a document to this witness. Therefore, it is relevant. And as far as hearsay, When it comes to membership of conspiracy, the court can take the statements of members and charged and uncharged to determine the existence of the conspiracy as well as the defendant's membership within that conspiracy.
Counsel.
Thank you. The notion that some of these people may be uncharged co-conspirators, I think the government has to identify who those people are. And so even if they are allowed to play the video, I think we need to know if there are 6 people on the video and 3 are uncharged, which ones they are alleging are uncharged co-conspirators. Because then if they're not uncharged co-conspirators, that takes us into, again, an entirely different analysis. Thank you.
Counsel.
That's not required with this witness. I just have to establish it during the tendency of these proofs.
I tend to agree with some of the objections and some of them I don't. I think that my agreement with some of the objections is that it may be premature to play portions of this video. I don't know what the evidence is going to roll out. I don't even know what this video is going to purport to show the court other than what this witness has already testified. So I'm going to hold the objections in abeyance and take it under advisement, and I'll make a ruling later on as the proofs are rolled out. You can continue.
Is the argument admitted?
Give me just a moment because I'm trying to see if there's some media. I'm trying to see if they have a media pass here.
Okay.
Okay, for the purposes of the proceeding, yes, you can admit it now while the objection is being taken under advisement.
Thank you, Your Honor.
So you're telling us we can't enter? Yes. Okay, would you say that on the What did he say? He said we can't enter.
What I said was, for the Capitol Commission, for the governor's office, for the Speaker of the House, for the Speaker of the Senate, the Capitol is closed unless you have an office here that conduct business today, or if you are taking part in the Electoral College process. Anybody else is not permitted to come in.
They are here to.
The electors are already here, they've been checked in.
They're also elected.
Capitol is closed. All 16 electors that we've been advised by the governor's staff that we're going to be here to vote in the Electoral College have been checked in, they're already here.
But these are the rest of the electors.
I understand. But the Capitol is closed, everybody is permitted to come forward.
Captain, the electors are also, the GOP electors are also on the governor's certificate of ascertainment.
I'm not going to get into a political debate. I'm following
It's not a
orders.
political debate.
Okay.
It's the official sealed document. The certificate of ascertainment has also the GOP electors. They are here. They're trying to do their constitutional duty.
I understand.
And their constitutional duty requires them to be at the Senate chamber today at 2 p.m. Okay. They're here.
They're not, I understand they're not being permitted in. If you have a problem, you can contact the governor's office, the Speaker of the House, the Senate Majority Leader, or.
I saw the governor's press release this morning. It's due to COVID. Is that the reason being given?
No.
All right, that was what the press release said. Is there another reason why?
You'd have to ask the governor's office to answer that question. I don't have.
We have a copy of paperwork that was prepared as electors under their constitutional duty. Can I speak to the Sergeant at Arms of the Senate to deliver it to the chamber today?
He's in a meeting right now with the Electoral College. He's not available to meet.
Captain Green, is it Captain?
First Lieutenant Green.
First Lieutenant, can you deliver this?
I cannot.
Okay. Is there anyone here that's willing to?
Mariana, I'm going to stop this video at about 2 minutes and 4 seconds. Captain Green, at the point that we just watched before, There's a man on the video in a camo coat. He had an envelope in his hand. Did you try to do anything with that envelope while you were standing at the door?
I mean, he had asked me if I was be able to deliver it to certain people that might be inside the Capitol. And I told him that I would be, accepting documents or making deliveries for him.
Did that man in the camel coat say what was purported to be in the envelope?
Objection, Judge, hearsay. I think the court has, I don't know if the court's ruled in this specific statement. So trying to identify was by having this person, their statement come in to say that what is inside this envelope is obviously using it to prove the truth of the matter asserted. It's hearsay, and again, we can't cross-examine this person in the camel coat, which is a statement apparently this witness is going to testify to. So under those circumstances, it violates the rules of evidence, and that's why I'm objecting.
You want to respond?
Yes, one, it's not hearsay for two reasons. One, this shows the attempt to publish. And as an author of proof, I'm going to say the man in the camel coat is an unindicted member, an uncharged member of the conspiracy. But any statements that he makes would be in furtherance of the conspiracy and would be used against all other members of the conspiracy. And second, it would go to the effect on the listener and Captain Green's decision not to take the envelope on that day.
So it's not being offered for the truth of the matter asserted?
Yes, I'm not saying that it's the truth of what's in that envelope because there's no way that Captain Green would know what is or is not in that
It's
envelope.
not being offered for the effect on the listener.
Yes.
The objection's overruled.
Your Honor, may I ask, how would the court prefer us to handle objections? So for example, I join in the objection. I know the court already made its ruling. Do you want us to all pipe up with me toos, or would your preference be that unless we say we do not join in, the objection is for all?
Unless you don't tell me that you join in, it's not going to apply to all. It's just going to apply to whoever stands up. So if you stand up, that'll alert me that you want to place your objection on the record, and I will give you an opportunity to put your objection on the record if you stand up during that objection.
Thank you. Then I do join the objection. I also would ask that the man in the camel coat be identified by name. Thank you.
Well, as an offer of proof, he identifies himself in the video.
Okay, great. I just, for the record, I think it's important to know who the man in the camel coat is.
Okay.
And
Counsel.
it's tough to hear the video.
It was a little tough. I'm going to have her replay it in just a
Okay.
moment.
And Your Honor, should we identify ourselves every time we stand up?
Yes, just so the record knows, because there's so many defendants. So we need to know who you are and who you're representing.
This is George Brown. I represent Ms. Henry. We join in the objection.
Okay, thank you.
Dwayne Sullivan on behalf of Michelle Lundgren, I too join in the objection.
George Danini, I join as well. Thank you.
Thank you.
Nick Sandberg, on behalf of Sean Mehta, we joined the objection. I thought the court wanted us to only, that we automatically join unless we say we're out.
No, the opposite. Correct. If only one person stands up and objects, then I'm assuming it's only their objection. If you all have not been, I don't, last I checked, you weren't working on your defenses together on this. Everybody was individually represented. So you need to make your individual objections. And so if one person makes the objection, I just need you to stand up so that I know that you two are going to join that objection. Otherwise, it's only going to apply to the person who put their objection on the record. Okay. And I already overruled the objection for the purpose that she said it's being offered for the effect on the listener and not for the truth of the matter asserted. Okay.
Did the gentleman in the camel coat tell you what was purported to be in that envelope?
It's been 3 years and I couldn't really hear the video, so I can't answer that 100%, but I do know, remembering back then, that I was definitely thinking that it was something to do with the Electoral College, and he was trying to get to me to get inside the people.
And did you or did you not take that envelope?
I did not.
With that, Your Honor, I will continue to play Exhibit 10.
I think it would benefit some of us to replay a portion. Is that what you needed?
I think the whole thing is difficult to hear. I mean, I have seen it in the discovery that we've received, but just if a record is being made of what's being said in the video, I think that it probably would be challenging for any court reporter.
And the initial part of the video is hard to hear. I'm not sure if the court is able to turn up the TV just a little bit more. It does get a little bit louder when the wind dies down, but initially at the door, it is very hard to hear.
We are at the max right now, which wasn't too far from where we already were. I don't believe the court recorder had any issues with hearing the video, so I think it was just those of us in the courtroom that had the issue. We also have fans going, so that doesn't help.
Would the court like me to restart the video?
Yes, please.
So you're telling us we can't enter? Yes. Okay, would you say that on the record? That we can't use that? What did he say? He said we can't enter.
What I said was, for the Capitol Commission, for the governor's office, for the Speaker of the House, for the Speaker of the Senate, the Capitol is closed unless you have an office here to conduct business today, or if you are taking part in the Electoral College process. Anybody else is not permitted to come in.
They're here to take part in the
Yeah, the electors are already here, they've been checked in.
They're also elected.
Capitol is closed. All 16 electors that we've been advised by the governor's staff that we're going to be here to vote in the Electoral College, we've been checked in, they're already here.
But these are the rest of the electors.
I understand, but the Capitol is closed, everybody's permitted to come forward.
Captain, the electors are also, the GOP electors are also on the governor's certificate of ascertainment.
I'm not going to get into a political debate, I'm following
It's not a
orders.
political debate.
Okay.
It's the official sealed document. The certificate of ascertainment has also the GOP electors. They are here. They're
Okay.
trying to do their constitutional duty.
I understand.
And their constitutional duty requires them to be at the Senate chamber today at 2 p.m.
Okay.
They're here.
All right, they're not, I understand they're not being permitted in. If you have a problem, you can contact the governor's office, the Speaker of the House, the Senate Majority Leader, or.
I saw the governor's press release this morning. It said due to COVID. Is that the reason being given?
No.
All right, that was what the press release said. Is there another reason why?
You'd have to ask the governor's office to answer
All
that
right.
question. I don't have.
We
any
have a
knowledge.
copy of paperwork that was prepared as electors under their constitutional duty. Can I speak to the Sergeant at Arms of the Senate to deliver it to the chamber today?
He's in a meeting right now with the Electoral College. He's not available to meet.
Captain Green, is it Captain?
First Lieutenant Green.
First Lieutenant, can you deliver this?
I cannot.
Okay. Is there anyone here that's willing to allow us, I've got elected officials and electors,
Okay.
to deliver this to the Senate today at 2 p.m.?
Okay. I can ask the Senate Majority Leader, the House Majority Leader, and
Senator Mike Shirkey, would you deliver that to him?
I-
Tell him Ian Norton.
you can contact his office directly and make arrangements to drop that off to him. So I'm not
Well,
going
they're
to
not,
take anything.
you're not letting us in the building. His office is inside.
He's not here.
What's that?
He's not here.
So are you telling me that the Senate chamber is in session and the Senate leader's not here?
Yeah. So you'd have to contact his office and make arrangements to meet with him to turn over.
All right, somebody from the governor's team that's running this? is
You'd have
she
to
willing
contact the governor's office with their team to make arrangements for them.
All right, again, the electors by statute, it's statute MCL 168.47 have to be at the Senate chamber today.
Okay.
At 2 p.m. They're trying.
I'm telling you that they're not going to be allowed to enter the Capitol, sir.
All right, thank you, Lieutenant.
You're welcome. Thank you.
What was your hope and plan today by coming here?
The electors can speak for themselves, but the hope and plan is for them to follow their constitutional duty. Under the U.S. Constitution, not just the Michigan Constitution, but under the U.S. Constitution, the electors have a duty to vote for their chosen candidate. In this case, the GOP electors slate their chosen candidate, President Trump. The Democrat electors are inside, I'm told, slating their chosen candidate, Joseph Biden. There's actually Green Party and Libertarian Party electors selected before the election as well. So the statute says it has to be done at 2 p.m. That's why they're here trying to do it. That paperwork is signed, it's sealed, and it's trying to be delivered. Stevie Wonder and Motown, I think, said that a little better than I did. But the point is that's not being happened. They're being stopped from fulfilling their constitutional duty. Now, I would call upon the Michigan legislature in the People's House. This is the legislature building in the People's House to finish their investigation so that we know which set of electors should ultimately be chosen before a rash decision is made, especially while that investigation is ongoing, especially why a judge up in Antrim County, Judge Elsenheimer, issued just this morning released a previously sealed or previously proprietary report, a forensic report that shows the voting machines used in Antrim County and in several other important counties throughout the state showed an error rate above 60% on the tabulation of the counting of votes. Under Michigan law and under federal law, under the Help America's Vote Act, that error rate is supposed to be less than 0.2%. But in Antrim County, based on those machines, the error rate was over 60%. And it would kick it into a adjudication by software, by code. It would kick it into an adjudication where the error rate was over 80%. That affected the race up in Antrim County. It was called user error and human error. That wasn't the case at all. That report released this morning over the objections of the Attorney General's office and over the objections of the Secretary of State's office. They tried to prevent that report from being released. They tried to keep that concealed from the people of Michigan.
Your name?
My name is Ian Northon, IANNORTHON. I'm a private attorney. I'm representing a charity called the Amistad Project. It's a 501c3, and it's affiliated with another charity called the Thomas More Society out of Chicago. We filed several pre-election lawsuits on election integrity. Every elected official, including the legislators and including everyone else here, the governor and everyone else, has a constitutional duty to ensure the accuracy and integrity of the election. And that's what these electors were trying to do here today.
I didn't want to interrupt because the video was going. I object to anything that man said that wasn't in the presence of the witness, because the only reason it was admitted was the effect on the listener. And I'm going to understand what happened just now is that this witness was not present for any of that narrative that person just said to apparently a reporter.
I would ask the court to hold that in abeyance until all the witnesses have testified. There will be more witnesses that are able to give context to that statement, but I would agree that this witness cannot testify to what Mr. Northon said outside of his presence.
Are you joining that objection?
Mary Ann Henry joins in that objection.
Thank you. Anyone else?
Mary Chartier joins in that objection, and Kurt E. Kraus on behalf of Mr. Haggard.
Blaine Silverman on behalf of Michelle Landry joins in the objection.
Objection is noted, and that will also be taken under advisement. Okay.
Now, Captain Green, did you ultimately let that group into the Capitol building on December 14, 2020? Nothing further of this witness. The people will pass the witness.
I need to take a brief recess. This witness can stay right there. I just want to back.
May I ask one quick question?
Yes, sir.
Do you have a preference on the order?
I have zero preference on order. I don't care if you all play pop, paper, rock, scissors. If you all can pick, this will be a perfect time to figure that out while I take a quick recess. Who thinks they should go first? Because I really couldn't tell you. And I think you all would best know how you all wanted to flow this out.
Very good. Thank you, Judge.
How long will we be in recess?
I'll give you 5 minutes.
Okay.
Your Honor, maybe because of that shield, we're having a hard time hearing.
It's not just the shield too, it's because that fan is right above your head. So you can't hear the witness or me.
I'm having a hard time hearing you, Your Honor.
Okay, I can speak up. Is that better?
That is better, Your Honor.
Okay, thank you. So I'll do that and I'll make sure that the witnesses are doing the same. If for whatever reason our voice drops, please just shoot your hand up to remind us to raise our voice, because it's the fan that's in that, of course. I don't even know if I can remove this. This is coming down, right?
I hear you.
Thank you. Okay, we're back on the record. We're gonna cross-examine this witness, and you're still under oath. I hope you all figured out who's gonna go first.
Yes, Your Honor, I'll be going first. Would the court prefer that I speak from here, my voice is fairly loud, or go to the podium? I know it would be awkward, I think, for witnesses to have to turn to the right, but whatever the court's preference is.
Oh, I can hear.
We can hear you clearly. I think it would be really clustered if you had to stand in between there, so we're just gonna ask him to turn and face you.
Great, and I'm not slender enough for that very small space that I see there, so okay, that's terrific. So Captain Green, this is a bit unusual. I need you to turn to your right and chat with me. My name is Mary Chartier. I represent Mr. Haggard. I want to ask you a few questions about your interaction that we saw in the video and just that day in general. So were there extra security officers at the Capitol that day?
Yes.
Do you remember how many?
I don't, off the top of my head, no.
Could you give us at all an estimate, over 50, under 50, anything like that?
Under 50.
Under 50? Were you normally assigned there, or were you an individual who had a special assignment that day?
No, that was my normal assignment.
The video that we saw, the gentleman in the camel-haired coat, you'd agree that's not Mr. Haggard, correct?
Yes.
You've seen that video probably a few times now?
A few, yeah.
Would you agree with me, Mr. Haggard is not in that video?
Yes.
The individual who identified themselves as a lawyer, you have no reason to believe he wasn't a lawyer, correct?
No.
And he was talking at least to you about statutes and the Constitution and why he wanted to enter, or at least hand you that envelope.
Yes.
There were other, to your knowledge, Republican electors who were with this lawyer, correct?
Yes.
And you don't know, based on that video, or your interactions, what that lawyer may have told the Republican electors, correct?
I have no idea what you were told.
There was nothing that you saw in your interaction with this lawyer that, for example, you have no indication that he did not genuinely believe what he was saying, do you?
No.
He didn't like say, haha, just a joke, or I'm lying, or anything like that, correct?
That's correct.
And of the individuals who you may have seen and heard there, you didn't hear that from any of them, correct?
Not that I recall. No.
After your interaction with the folks at the door, what did you do?
I probably went back in and then started my rounds of the Capitol, checking on my people and making sure that everything was business as usual for the people that were allowed inside the Capitol that day.
Did you write a report or anything about that interaction?
No.
And I know you're a police officer. And how long have you been an officer?
Just over 23 years.
When you witness a crime, do you write a report after that?
Yes.
So for example, if you saw me punch Mr. Kraus in the nose, would you write a report? And he didn't ask me to do it. Would you write a report about that and say, gee, I think I just witnessed a crime?
I would, yeah.
And you didn't do that in this case, did you?
No.
The envelope that lawyer attempted to hand you, you don't know what was in that envelope, do you?
No.
And to your knowledge, that envelope did not make its way into the Capitol?
To my knowledge, no.
Do you know whatever became of that envelope?
No idea.
Did you see that lawyer hand that envelope off to anyone?
I don't recall.
So to the best of your memory, he had the envelope in his hand, and then you don't know what happened to it next.
That's correct.
And to be clear, have you ever interacted with Mr. Haggard at all?
Not before today.
Right, not before today. One moment, please, Your Honor.
No problem.
I have nothing else. Thank you.
Next, counsel.
George Robert, Mary Ann Henry Trooper. There weren't any events or interactions before or after this video that you witnessed, correct?
Related to.
Involving this group. There weren't any interactions between you and anybody in this group that weren't on video, correct?
Correct.
And you see the woman sitting next to me?
I do.
You can identify as Mary Ann Henry. You didn't see her that day. It's,
It was 3 years ago. I don't recall.
you can't identify if she was there or not.
I can't.
No further questions. Sir.
I'll go, Your Honor, Nicholas Sonberg, back from Sean Meta.
Give me just a moment. Okay, you can see.
Thank you. Lieutenant, is it common for people or groups of people to try to attempt to enter the Capitol building when it's closed?
It's not common, no.
Have you ever seen it happen?
I have seen it happen, yes.
And in your experience, are such attempts typically associated with protests?
For the most part, yes. Or just people that are confused and wonder why they can't go into the people's building, as it's often referred to.
How long have you been in your, what is your position specific to the Capitol?
So when I was at the Capitol, it was state security operations, and part of the umbrella that I was responsible for was the physical security of the exterior of the Capitol, and then all common areas inside the Capitol. And I held that position from June of 2019 until May of 2022.
And specific to your experience and your responsibilities to the physical security of the Capitol, people do maybe show up to protest outside of business hours.
Absolutely.
People may show up in the middle of the night.
Sometimes.
Is that correct? And how do you typically handle these situations?
You just either, if it was me personally or my officers that I supervised, it was to contact those people and kind of explain the rules and regulations and the policies that were set forth by the Capitol or the Capitol Commission about when the Capitol was open, for what type of, protests or places you could congregate. You could bring signs in, weapons, things like that. It's just to educate them about what the rules and policies of the Capitol were.
And is that what you did on this day?
I guess I didn't really explain. I just let them know that the Capitol was closed because that was the direction that I was given on the day.
Did you have any interaction with my client, Sean Meta?
I feel, is he a state rep? Is he a state rep?
Sean's a woman.
Oh, okay, then,
No.
there was a representative, Matt, I think, when I was at the Capitol, but I recognize the last name, but I don't think I would know who you're talking about.
You recognize the last name, Matt, as a state representative, but you did not have interaction with my client, Sean, on that day.
That's correct. Or not to my knowledge, I don't recall.
Thank you. No further questions.
Anything else?
No, go ahead.
Judge Garrett Koger on behalf of Ms. Burden. Is it all right if I use this
Yes.
corner here to rest my
You're not
mind?
near a mic, so we just need you to come over a little bit here. You can just stand right there. There's a mic right there.
Okay. Trooper, you watched the video that the prosecutor just played, correct?
Yes.
Twice in full?
Yes.
Do you know who Kathy Burden is?
No.
I represent to you that that lady right there is Miss Kathy Burden. Would you agree with me that Miss Burden is not on the video you just watched twice?
I didn't see her on the video, so I would agree with that.
You've been a police officer or a trooper. I'm sorry, I know you guys don't like to call police officers. You've been a trooper for over 23 years, right?
Yes,
It's fair to say you've been collecting criminal contraband that entire time?
Actually, in my earlier days, yeah.
In this case, were you warned that there could be people walking around with fraudulent documents and try and get in the Capitol building?
No.
Testified that you did not take the envelope that the gentleman in the tan overcoat tried to give you. We're not dealing with cocaine or methamphetamine, which I am sure you have experience with, but is it fair to say that you did not immediately recognize that document as a criminal contraband?
That'd be correct.
You didn't suspect that there could be a forged document in that envelope?
No idea.
Are you aware? In fact, if you had suspected that, you would have a duty as an MSP trooper to confiscate it, right?
Most likely, yes. Yeah,
Is it a yes or most likely?
I
Not a
guess,
statute that says you have to act
yeah, I mean, if there was a crime, then yes, that actually.
specifically felonies.
Yes.
So at the time, when this group that was on the video was trying to publish to you a document, or the gentleman, I should say, on the video was trying to publish to you a document, you didn't immediately recognize that as a felony.
Right.
Let alone 8 felonies, right? If you had, you would have had to confiscate the contraband, right?
Correct.
And arrest the people, right?
Yes.
Here, of course, you didn't arrest any.
That's correct.
Is it fair to say that on December 14th, 2020, as a very seasoned lieutenant, I guess by then you would have had 20 years experience as a trooper, right?
Correct.
You were not under the impression that anyone there was committing a crime, let alone 8 felonies.
That's right.
Oh, Trooper, are you aware that there are 2 documents at issue bearing Kathy Burton's signature?
I'm not aware of that.
Okay. And again, you cannot say what was in the envelope you didn't confiscate, right?
Okay.
Nothing for you, thank you.
I don't have any questions, Your Honor.
State your name for the record, please.
Oh, I'm sorry, Paul Stanton.
Thank you. Mr. Silverthorne?
You've heard the video, correct?
Yes, sir.
And did you agree that there are a lot of voices speaking at the same time?
Yes,
Often classified as speaking over each other, is that correct?
that'd be correct.
You didn't hear anyone in that group yell, "We're the elected, did you?
I didn't hear that, no.
Have you had any interaction with Michelle Lundgren?
Not to my recollection, no.
And you didn't see her in that video, did you?
I don't recall seeing her in that video, no.
And specific to Michelle Lundgren, you didn't hear any individual voice say, "We're here as an elected," did you?
I didn't hear that, no.
Thank you.
I think we got everyone.
But an additional question, Your Honor.
Additional question?
Yes.
Okay.
George Brown from Mary Ann Henry. Trooper, you had been warned there may be people trying to enter the building?
Not to my recollection. I was just told that there was only going to be certain people allowed in the building that day. And at that point where that video took place, I had already been made aware that the people that had permission to be in the Capitol building that day to participate in the Electoral College had been checked in and were there, and then no other people were going to be allowed inside the Capitol building unless they had office there and were there conducting business.
Were you given any indication that anybody may be arriving?
No, I had no idea.
And were you there 4 years prior during the last count?
I was not.
No further questions, Your Honor.
Redirect.
Yes, Your Honor. Thank you. Why was there extra security on December 14th, 2020?
I think based on the contentious presidential election and just the atmosphere around the Capitol and politics in general, there was just a heightened sense of security and wanting to protect the infrastructure of the Capitol building.
And were there any protests on December 14th, 2020?
I don't recall. I don't believe that there was. There was a ton of them in my time at the Capitol. They kind of tend to run together a little bit. But I don't recall anything on the 14th that triggers my memory.
And the group that attempted to enter through the annex, did that group self-identify as protesters?
No.
And you did not take that envelope, correct?
I did not take it.
And did you allow that group to enter?
No.
Thank you.
Who's going to speak, excuse? May this witness be excused?
Yes, please.
Okay, thank you, Cooper. Captain Green.
Thank you, Your Honor. No further questions for the witness. I just wanted to clarify an objection.
You want to clarify an objection?
Yes, there was an objection as to the statements being made by the person who identified himself as the attorney.
Okay,
And I wanted to clarify that Mary Ann Henry, she was not objecting to statement being made by the attorney.
he does not object?
She was not objecting.
Okay. Counsel?
And same, and I would echo that from Michelle Mehta. We do not object to the person identified, who had self-identified themselves as an attorney that his statement.
Anyone else? Okay, that's noted.
Thank you, Your Honor.
Thank you. You can call your next witness.
At this time, Your Honor, the people will call Mr. Jonathan Brader. Special Agent Shock, once again, I'm just going to make use of this time and show my exhibits to the defense counsel. And this.
Do you have extra copies? You want to do something? How are we gonna track your numbers? It's gonna be a little bit. No, she's just showing us.
I'm showing
Oh,
this to you.
Okay, no, right, I just,
I mean, if you want to stick with that, makes my life easier. I mean, no, I'm just showing it to you. So. For the candidates who certificate. Certificates for the 16 Democratic electors. 2020 amended certificate of master degree. These are all documents that should have been in this document. 2020 certificate of votes. Certificate as can. These are going to be in numerical order 1 through 7. Sorry. This one's. This is the 2016 certificate. The 2016 certificate of votes. 5 and 6. And exhibit 7 is an email to Jonathan Brader from the U.S. National Archives, sending the Republican certificate of votes. The captain. Well, sending it to him for the first time.
Oh.
Saying, hey, we got this.
no, but the thing is, they received it, so they're saying it to- right, so.
Which one does?
No, I'm just writing.
I'm sorry.
Yeah, so I'm trying to do this in numerical order.
Off the record. Are you ready to go back on the record?
Yes, Your Honor.
Okay, back on the record, and this is your witness that you called?
Yes.
Sir, can you please stand and face me? Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Thank you. Have a seat. You can state your first and your last name and spell both.
Jonathan Brater, JONATHAN BRATER.
Seat, counsel.
Thank you. Good morning, sir.
Morning.
Could you please tell us where you were?
I work at the Michigan Department of State in the Bureau of Elections
And how long have you worked for the Michigan Department of State?
since January of 2019.
And how long have you been specifically in the Bureau of Elections?
I've been in the Bureau of Elections as a director since January 2020.
And as the director of the Bureau of Elections, does that mean you have familiarity with the process of how an election is to be conducted in the state of Michigan?
Yes,
Does that include presidential elections?
yes.
Now, as it relates to how candidates for elector are selected in the state, could you tell us how a candidate for elector is selected?
Yes, so following each state party convention, which in 2020 happened in late August 2020, the state party is certified to the Secretary of State the electors that are going to be on the ballot on their side. So there'll be 16 electors, or there were 16 electors in 2020, the Democratic Party and the Republican Party. Those are certified by the state parties to the Secretary of State.
Okay. And are you familiar with the authority that lays out that plan to select candidates for elector?
Yes.
And what is that?
That's in the Michigan election law.
Okay. And specifically for the court, I would ask the court to take judicial notice of Michigan compiled law 16841 and 16842.
So noted.
Now, once the parties select electors and they send that information to the Department of State, what happens next?
So the Department of State has that information. The ballots are then printed for the November election. The ballots include the names of the candidates for president for each party, rather than the names of the electors. However, following the election, when the canvass is completed and the results are certified, it is technically the electors who are certified as having been duly elected to vote for the candidate and party with which they're associated.
And how do you decide which party's candidates will be duly elected?
So the first step is in each county, there is a county canvass. So in each of the 83 counties, Board of County Canvassers, which is comprised of 2 Democrats and 2 Republicans, canvasses the results of the election in each of their 83 counties. They then certify that information to the Michigan Secretary of State. Following that, the Board of State Canvassers then convenes. They compile all of the canvasses from the county level, and then they canvass and certify the results of the election statewide. So following that, following the canvass of all of the county results, they then determine which, in the case of the presidential election, which electors were duly elected in the election.
When the Board of Canvassers certifies the votes, do they create a document putting their findings of which party they've determined has won the vote?
Yes.
Permission to approach the witness, Your Honor?
You may.
And this has been shown to all parties. I hand you what has been marked as People's Proposed Exhibit 1. Do you recognize that document, sir?
Yes.
And what is that?
This is the official canvass of votes that the Board of State Canvassers completed following the canvass in 2020. It occurred on November 23rd of 2020.
And is that a record that is kept in the ordinary course of the state's business?
Yes.
People would move to admit People's Proposed Exhibit 1.
Any objections?
Yes, Your Honor. On behalf of Kathy Burton, I object on the basis that I believe that document has on it the signature of Mr. Aaron Welby. I might have just butchered his name. At the time, he sat on the Board of State Canvassers. And he voted to certify the election, to my understanding. Since then, he has joined the Attorney General's office to the extent that this is offered with his signature. In other words, his statement that he's adopting. It should not be admitted with him in the room if he's going to testify. There's a sequestration order. And it makes him a fact witness, Your Honor. So to the extent he's working on this case within the Attorney General's office, there should probably be a conflict wall, and he shouldn't be working on it because he is a fact witness, as the prosecutor just highlighted for the court. That's my objection.
Well,
Mary Chartier join in Mr. Coger's objection.
George Brown for Mary Ann joining.
Paul Stavlin joining. Wayne Sullivan joining on behalf of Michelle Underwood.
Rick Sumberg joining from John Matter.
Respond.
well, one, this is a business record kept in the ordinary course of business. It is also a public record. And the authority for those are Michigan Rule of Evidence 8036 and 8038. As it relates to Mr. Van Langeveld, and I hope I said it right because it didn't. At the time that this document was executed, he was on the Board of Canvassers. He is not going to be a witness in this exam or this trial, and there is no conflict because this document speaks for itself. As I said, it is a public record and it is a business record, and it is, as I said, it speaks for itself. There is no conflict. The conflict assessment has already been done, and there is no conflict.
Your Honor, may I respond to that?
I'm sorry. You need to just come closer to, you gotta get closer
Sure.
to the mic, please.
I
Thank you.
appreciate that the prosecutor doesn't intend on offering him as a witness, but we're a long way out from trial. I'm not sure that one of the 16 defendants won't call him as a witness. So just because the prosecutor decides not to call him doesn't mean that the defense doesn't have that opportunity at a trial. Granted, preliminary exam is their show, they can do what they want. However, for the preservation of all the defendant's rights and using him as a witness, I think he needs to be, number one, asked to leave the room. Number two, the Attorney General should revisit their conflict procedure within the Attorney General's office. I know from personal experience, as does Your Honor, there's roughly 300 AAGs. I don't think it's at all a coincidence that Mr. Langeveld is participating in this case. And I, again, assert my objection, John. Thank you.
Thank you. Any further response to that?
No.
Okay. Thank you, Mr. Kroger, for pointing out that I too am aware of the Attorney General's conflict law procedures. This is the witness or the potential witness that you're talking, what's your name, sir?
Aaron Van Langeveld, Your
Can
Honor.
you say that louder for me?
Aaron Van Langeveld, Your Honor.
Okay, this is the attorney that he's referencing? I'm not sure.
Yes.
Yes.
Okay, so the objection is that he was on the Board of Canvassers at the time of this alleged incident and now is currently employed by the Office of the Attorney General and is now working on this case.
Yes.
And the Office of the Attorney General, they've done their clearance or their due diligence as it relates to any potential issues relating to conflict.
Yes.
My personal recollection of being at the Attorney General's office is that they were pretty astute when it comes to making sure there was appropriate conflict walls placed up where necessary. I'm not here to determine whether or not they did that. I don't have any information before me to determine whether or not they dropped the ball on that. I don't know that this witness is going to be called today. Did any of the defense counsel subpoena this witness for today's purpose? Which is the purpose of the preliminary examination, because this is not the trial. And you wanted to add something, sir?
Yes, Your Honor. The person we're speaking about, he wasn't merely involved in Board of Canvassers. His decision whether or not to certify the 2020 election was a matter of much media speculation. I anticipate that during the pendency of this case, if it is bound over, that he very well may be a witness.
Okay, but he's not been called as a witness for today's purpose. He's not a witness today. He's currently employed by the Office of the Attorney General, and they don't see it as a conflict for him to work on the case.
Oh, I'm sorry, Your Honor, if we had Donald Trump in the courtroom today, I doubt he would be sitting on the AG's side, and certainly there would be some kind of objection. Now, nobody's calling that person today, but we anticipate that they may be a witness.
If Donald Trump was working at the Attorney General's office, you
I'm
saying?
saying, Your Honor, sorry,
I'm trying to follow your analogy.
the person we're talking about here was not just part of the election. He was one of the 2 Republican boards of canvassers on the board of canvassers, and his decision whether or not to certify the 2020 election, which is very much at the heart of this case, was an issue at the time. And he may very well be called as a witness during.
I don't disagree, but the court doesn't get to determine whether or not the Attorney General had an appropriate conflict wall placed up. That I don't have authority over that. I don't get to place up a conflict wall on their behalf. He's now assigned to this case as an attorney.
All right, I think that wasn't the only, I'm sorry.
There's appropriate mechanisms for if you believe there's a violation of conflicts as it relates to an attorney, and it's not in the courtroom. I don't make decisions about conflicts.
Your Honor, I'll leave it to brother counsel. He had additional requests.
Well, we have order here. I can't see back here, sorry, because they gave me a new monitor. You have to step up or raise your hand because I sometime will miss who's behind there. Counsel.
Thank you. I join in the comments and objections by counsel. At the very least, he should be sequestered during the pendency of the exam, because while he might not be a fact witness at the exam because of the issues that the court needs to determine to bind over, I can assert that I believe he will be a fact witness at trial. And while the Attorney General's office, I have no authority over what they do, and I understand the court doesn't either, I do think it's important to place on the record that they are creating, it appears, quite the conflict, because a lawyer cannot serve as a lawyer and a fact witness on the case. Thank you.
I was joining in the comments as the court orders defense witnesses sequestered every week, probably almost in every trial that aren't called. Also, I don't think the Attorney General has the power to prevent the defendants from in the future calling this gentleman as a witness by the rules of putting him on this team, when it clearly would have been advised in advance that he had the potential to be a fact witness. It can't be a mistake.
Mr. Kroger?
Sorry, Judge. That's an impressive screen.
It's new.
Yeah, Judge, I just refer back to your initial sequestration order and ask that be enforced. The only exception was for investigator Shock, and then I'm sure there will be a discussion at the Attorney General's office later as to conflict laws. I agree with Your Honor that is up to the Attorney General's office, and we can go from there. But for the time being, I think a sequestration order enforcement is in order. Thank you, Your Honor.
Thank you. I agree. I don't see how this particular attorney could not be called or would not be called as a witness if he was one of two people to certify. It's one of 3 people, either way. I'm inclined to believe that if his name is on this document that's trying to be admitted as a business record, he could be called as a witness. So sequestration was ordered and he needs to be removed from the courtroom. Okay, you can see, counsel.
I still renew my motion to admit people proposed exhibit 1.
I think the only objection I had was to that particular witness.
That's correct, Your Honor. No objection is to the document.
Okay, so yeah, without any further objection, people's exhibit 1 is admitted.
Thank you. Mr. Brader, referring to People's Proposed Exhibit 1, does that document identify which parties candidates for electors would be selected as the electors to cast the vote for the state of Michigan?
Yes,
And which party would that be?
the person's nominated by the Democratic Party.
Is there ever a time where two parties, electors would be duly elected?
Not that I can think of.
Now, after the Board of Canvassers, and I'll take that back, certify the vote for the state of Michigan, what's the next thing that happens as it relates to the presidential election?
Each of the electors that is duly elected receives a certificate indicating that they were duly elected. And the electors then convene at the state capitol. In this case, it was on December 14th to cast their votes in the electoral college president.
Permission to approach, Your Honor. Right. They hand you what has been marked as People's Proposed Exhibit 2. It's a document, a total of 16 pages. Do you recognize that, sir?
Yes.
And what is that?
This appears to be copies of, I'm assuming there's 16 here, of the certificates of election that were provided to each of the electors who were duly elected.
For what year?
For 2020.
And does each page bear the name of one of the duly elected electors for the state of Michigan?
Yes.
Does it also bear the seal of the state?
Yes.
People would move to admit People's Proposed Exhibit 2.
Any objections to People's 2?
I'm from Kathleen Bird, no.
Admitted without objection.
Would the court like me to publish these exhibits as I go along?
That would be helpful.
Before I publish Exhibit 2, that's Exhibit 1. On the certificates, does the certificate itself advise the elector of what they're supposed to do and when they're supposed to do it?
It advises them that they were duly elected for a term ending on December 14th, 2020. It doesn't give them specific instructions on what to do.
Oh. Now, as it relates to sending out those certificates, what's the next thing to happen after the certificates are drafted and sent out to the electors for the state of Michigan?
So at that point, on December 14th, the electors convene at the state capitol, the Senate chamber, to cast their votes in the electoral college.
Council, were these already marked?
Yes. The last page just marked.
Oh,
sorry.
Maybe it's out of order. Oh, I see, it's a light stamp. Okay, you can continue.
And how is it determined that December 14th, 2020 will be the date that the electors convene in the Capitol?
That is based on requirements in state and federal law, but certainly federal law and the Electoral Count Act. There's a deadline by which electoral college can meet.
And Your Honor, I would ask the court to take notice of Michigan compiled law 168.47 as it relates to when the electors are supposed to convene and where. Now, we've talked about the Board of Canvassers certifying the vote for the State Board of Canvassers certifying the vote. If a candidate wants to challenge that certification, is there a procedure in place.
Yes.
What is that procedure?
I think there's multiple ways depending on what the challenge is. First, if candidates believe that any of the 83 counties should not be canvassing and certifying the results, those are done at public meetings, and they can appear at those county canvas meetings and explain to the county canvassers why they don't think they should be canvassing and certifying results. Similarly, at the Board of State Canvassers, there's also a public meeting, and candidates or representatives can appear at the Board of State Canvassers, make their case before the board why the board should not be certifying those results. Additionally, following certification, a candidate can request a recount. So the candidate has an opportunity to ask for a recount if they believe that the ballots were not properly tabulated in the election.
And to your knowledge, after the State Board of Canvassers certified the vote for Michigan, was there a recount request?
No.
And how long does a candidate have to ask for a recount?
In the case of a state certified election, it would be 48 hours after the certification.
And the people would ask the court to take judicial notice of Michigan compiled law 168.879, which lays out the procedure for requesting recounts.
So noted.
What about lawsuits? Can a candidate file a lawsuit?
Yes.
Okay, and if a candidate were to take the route of a lawsuit, would that be something that drags on for a long time, or would the courts be amenable to hearing it quickly?
In my experience.
Objection. He has no knowledge of what the courts, whatever courts are being referred to, what their timeline would be.
I join in the objection. It's speculation.
Mary Ann rejoins. Paul Stavlin, I join.
It's not really joint.
William Sullivan, I Michelle London joins.
Well, Your Honor, I believe this witness would have experience, considering he is the director of the Board of Elections for the Department of State. And part of that is dealing with whether or not lawsuits are filed and how quickly or slowly they are resolved in order to determine the finality of votes in elections.
Was your question phrased? It wasn't as it relates to his experience?
It was not, but I can rephrase.
Okay, so I was gonna say you didn't ask him in his experience, and my recollection of his testimony is he's been in his position since 2019. Is that
He's
correct?
been with the Department of State since 2019, I believe, in this position since
In this particular
2020.
position since 2019, is that correct? So, and this happened in 2020, so I guess he can, if you want to rephrase, he can answer as to what his personal experience would be. He can't speculate as to what all courts could do.
Agreed.
So to that extent, I'll sustain the objection. I'll let you rephrase.
In your experience as a director of the Board of Elections, as an employee of the Department of State and the Department of Elections, when a candidate challenges election results, is this something that is this a matter that is handled quickly, or does it drag out? If you know.
In my experience, I have experienced many lawsuits related to election procedures since my time as director of elections began. Typically, with election deadlines, there tends to be very little time for these issues to be decided before they reach the next procedural step. So typically, in my experience, those who are challenging the decision of election officials will ask for either a temporary restraining order or preliminary injunction and ask the court to rule quickly.
And is this something that you've seen before and after certification of the votes?
Yes.
Permission to approach, Your Honor?
Permission granted.
I hand you what has been marked as People's Proposed Exhibit 4. Do you recognize that document?
Yes.
And what is that?
This is the certificate of votes for president and vice president that was completed by the electors on December 14th, 2020.
No, I'm gonna hand you, because it was out of order, People's Proposed Exhibit 3. You recognize that document, sir?
Yes.
And what is that?
This is a cover letter along with an amended certificate of ascertainment that was submitted by the governor to the National Archives.
And what is a certificate of ascertainment?
Certificate of ascertainment is a document that's completed by the governor that indicates with the governor's signature as well as Secretary of State signature, the individuals who were elected as electors in the electoral college.
Does it also indicate the number of votes that that party obtained during the election?
Yes.
And is that a document that is created in the ordinary course of the business?
Yes.
People would move to admit People's Proposed Exhibit 3.
Any objection to People's 3? People's 3 is admitted without objection.
Now, looking at People's 3, does it say how many votes the winning party received for the state of Michigan?
Yes.
And which party is identified as the winning party in the ascertainment, the certificate of ascertainment?
The certificate indicates that the individuals nominated by the Democratic Party were duly elected as electors of president and vice president.
Okay. With how many votes?
2,804,040.
Now, does the certificate of ascertainment also identify the candidates for elector from the other parties?
Yes.
Okay. What is the party with the second most votes as identified by that certificate?
The Republican Party.
Okay. With how many votes?
2,649,852.
Now, looking at Exhibit 4, I believe you identified that as the certificate of votes that was executed on December 14, 2020.
That's correct.
And is that a document that would also have been kept in the ordinary course of business?
Yes.
People would move to admit People's Proposed Exhibit 4.
Any objections to People's 4? People's 4 is admitted.
Permission to publish Exhibits 3 and 4?
Yes, please.
Now, is this the procedure that has been set in place for other elections, other presidential elections in the state of Michigan?
Yeah.
And in 2016, would the then governor, Rick Snyder, have generated and submitted a certificate of ascertainment?
That is my understanding, yes.
And the electors, I believe from the Republican Party, would they have been called to the state of Michigan, to the state capitol to deliver the state's votes?
Yes.
Permission to approach, Your Honor?
Permission granted.
So I'm going to hand you what have been marked as People's Proposed Exhibits 5 and 6. I'm going to first call your attention to Exhibit 5, Proposed Exhibit 5. Do you recognize that document?
I'm sorry, which one is 5?
The one that was on top.
Oh, okay. Yes, I do.
Okay, and what is that, sir?
This is a certificate of ascertainment that was completed by Governor Snyder in 2016.
And as with the 2020 certificate of ascertainment, does it identify which parties candidates will be the duly elected electors for the state of Michigan?
Yes.
And would that be a record that is generated and kept in the ordinary course of business?
Yes.
People would move to admit People's Proposed Exhibit 5.
Your Honor, I object as to relevance. We're dealing with the 2020 election, not 2016.
I'm gonna have her respond. I'm sure you're joining. Is that
Yes.
correct? Okay, state your name.
Paul Staplin.
Thank you. Did you want to respond to that objection as to what the relevance would be?
Your Honor, the relevance is that to show that this is the procedure that has been in place and that what happened in 2020 with the Democratic electors has been the policy and procedure as per statute. And that what the defendants allegedly did goes far outside of what is known to be the standard. Even though we haven't gotten to what the electors did, I think it's important to see that this has been the procedure, whether the controlling party is Democratic or Republican.
Mr. Silverthorne, you were joining the objection?
Yes. I think the Attorney General is trying to impute knowledge from 2016 onto these individual defendant alleged electors. And I don't think that she's making the tie. She said that this is the procedure to be known. Be known by who?
Yeah.
None of the,
Sorry.
unless she intends to introduce evidence that all the electors understood what the procedure was, I don't think it's relevant.
Your Honor, Defendant Haggard was actually an elector in 2016, so I think it's it is readily relevant for his knowledge as to what the procedure is for duly elected electors and how they're to cast the votes for the state of Michigan.
Okay, so the purpose of this exhibit is just to show that the policy or the procedure hadn't changed?
Yes.
Okay, counsel?
Just wanted on the record, Your Honor, Kathy Burton does not object to that.
Anybody else want to join or not join in the objection?
Mary Ann Henry does not object.
The objection is overruled. People, this is 5.
Yes.
Is admitted.
Now, looking at People's Exhibit 5, I don't know if we said this already, but which party's electors were duly elected?
The Republican Party.
Okay. And looking at People's Proposed Exhibit 6, can you tell us what that is?
This is a certificate of votes for president and vice president that was completed by the electors on December 19th, 2016.
And does that certificate of votes identify where the vote took place?
Yes,
And where was that?
at the state capitol.
And is that a document that would have been generated and kept in the ordinary course of business?
Yes.
People would move to admit People's Proposed Exhibit 6.
Any objection to People 6?
Same objection if it's 2016. Thank you.
I agree. It's 2016.
Okay, and the objection is as to relevance, and that is to show again that the procedure hadn't changed.
The procedure had not changed, and specifically that Defendant Haggard was an elector in 2016. I've not had the witness identify that yet, but it is on the document itself, and that at least he had knowledge of how the policy and procedure was to be in place and the proper way to deliver the state's votes.
The objections overruled. People 6 is admitted.
Now, looking at People's Proposed Exhibit 5, does it list the duly elected electors by name?
Yes.
Is and on People's Exhibit 6, does it also identify the electors by name and also bear their signatures?
Exhibit 6, yes.
Permission to publish, Your Honor.
Permission granted.
And I would draw the court's attention to the third name on People's Exhibit 5. And also the third name on People's Exhibit 6. That is one of the defendants in this matter, Mr. John Hack. Mr. Brader, after December 14th, 2020, did there come a point in time where you were made aware that a second certificate of votes was delivered for the state of Michigan?
Yes.
And how were you notified?
I received an email from the National Archives.
Objection hearsay.
As to him receiving an email?
No,
Or
my-
if he's gonna tell what's the contents of the email.
Receiving the email is not hearsay, but it appears that he's about to go right into what's in the email, which will either be hearsay or implied hearsay.
Okay. Did you want to respond?
Well, we haven't gotten to the objectionable part yet, but I believe it will be effect on the listener.
Okay, not being offered with the truth of the matter asserted.
Exactly.
Okay, as to his response comes in because he's only responding as to how he, or what he received. He has not gotten into what the email stated, so I'll reserve that objection to if he gets into that.
Do you recall when you received that email?
I don't recall the exact date.
Would reviewing the email refresh your memory?
Yeah.
Permission to approach, Your Honor.
Yes, and while you are approaching, can you repeat who you received an email from?
It was from an individual at the National Archives. I don't
Okay.
remember the name of the individual.
Thank you.
Now, before I hand you this, is there something significant about votes going to the National Archives?
Well, under the Electoral Count Acts, that's the entity that receives the electoral, the certificate of ascertainment from the governor.
So when the certificate of ascertainment is executed by the governor, that is sent to the National Archives.
Yes.
Are the votes that are by the electors also sent to the National Archives?
Yeah, the certificate of votes is also sent, yes.
Are they supposed to be sent anywhere else outside of the National Archives?
I don't recall specifically. I believe the Congress might get a copy of it, but I don't remember exactly.
In the hand you was been marked as People's Proposed Exhibit 7. This is just to refresh your memory. So just let me know when your memory is refreshed as to when you received that email.
This was January 8th, 2021.
And so this is several weeks after December 14th, 2020. Is that fair?
Yes.
Okay. Now, not getting into the contents of what was in the email itself, did you review the email?
Yes.
And what did you do based on that email?
I believe I contacted the Attorney General's office.
And what was it about that email that made you contact the Attorney General's office?
Well, it was unusual to be informed that there had been a separate set of electors that had been sent to the National Archives, which were not the ones that the state of Michigan had submitted following the ordinary process.
Before you would receive this email from the National Archives, did you know anything about a potentially Republican slate of Michigan electors?
I'm sorry, I heard some questions. Did I know?
Like, did you receive anything, a certificate of votes from the Republican slate?
Not to my knowledge, no.
And did you review the attachment that came with that email?
Yes.
And is that a document that you had recognized before receiving it from the National Archives?
I don't believe so.
And did you look at the entirety of People's Proposed Exhibit 7?
No, just the first page.
Okay, could you look at the entirety of it now, please?
Okay, yes. Okay. Yes.
Now, the remainder of those pages was that the attachment that was included with the email you received from the National Archives?
Yes.
And is that the document that you forwarded to the Attorney General's office?
Yes.
Would move to admit People's Proposed Exhibit 7.
Any objection to people 7?
Objection, hearsay on behalf of the email, and I don't understand what hearsay exception would be allowing that to be admitted. I don't think it's a business record kept in the ordinary course of business because it does not appear to be a record produced by this gentleman or his office.
During that, Judge Paul Stanley.
Marion Henry joins. Michelle Maddock joins.
Kathy Burden joins.
Michelle Lundgren also.
Do you want to respond to the objection?
Yes, as the witness testified, when he received the email, he looked at the attachment and it caused him to contact the Attorney General because it was a document he had never seen. He had not been aware that there had been a Republican state slate of electors for the state of Michigan. And this document and this email shows the impetus of the investigation, as this document shows the attempted forgery and publication of this document. It does not have to be created by this witness, as we're not saying that this is a public document. We're saying that this is the body of the crime. And this is how the state of Michigan was made aware of the body of the crime, because the National Archives sent it to this witness and this witness forwarded it for investigation.
This is an email that you're seeking to amend?
The email is more effect on the listener and not for the truth of the matter asserted. As this witness stated, once he received the email, he recognized that this was not a document that his department had forwarded, and it was not a document that he was aware of, and that's why it sparked his desire to send it to the Attorney General's office for further investigation.
Okay, so it's not being offered for the truth of the matter asserted, but it's being offered to show what this witness did?
It gives context to what this witness did and context to the attachment, which is the proposed forged documents that were sent to the archives.
Respectfully, I think it is being offered for the truth of the matter asserted, despite the claim by the Attorney General's office, because if it wasn't being offered for the truth of the matter asserted, it certainly doesn't go to the body of any sort of crime. This witness can't testify as to what the National Archives received. That's why the email is here, to indicate that that's what the National Archives received. So they are trying to admit it for the truth of the matter asserted. This is an end run around that. And this witness can't say again what attachment the National Archives received. He only knows what he purportedly was emailed. And that's what they're claiming is a forged document. So it is being offered for the truth of the matter asserted. No one is challenging the effect on the listener. No one is indicating that Mr. Brader didn't contact the Attorney General's office. We'll get into the specifics of that. So that issue isn't in dispute. If that was potentially in dispute, maybe the email is relevant, but it's not relevant. It is hearsay and is substantially prejudicial to Mr. Haggard, because no one from the National Archives is here to attest that that's the document they received or whatever else they may have received or who they got it from.
May I respond, Your Honor?
No, you may.
Well, first, this document is not hearsay. As I said, it is the body of the crime. Now, Mr. Brader cannot say how the National Archives received the document, but he knows he received the document from the National Archives, and it sparked the state investigation as to the creation of the document, who created the document, the intent behind the document. It's the reason why we are here today, to look into this document itself. It is, like I said, the body of the crime. As it relates to the email itself, what Mr. Brader can say is, I received this email and this was attached to the email. And the context of the statements in the email give context, one, to how he responded and what he did with the attachment. It is not being used to say, this is a false slate. That comes later.
Your Honor, I just want to add, I think there's actually an issue of double hearsay in this case, because the first level is the National Archives receiving an out-of-court statement, and then the National Archives sending a communication to him. It's also hearsay. It has to pass the test of both.
Correct, but she's saying that it's not being offered for the truth of the matter asserted. The argument is that to the contrary, it is. So whether it's hearsay within hearsay, if she's saying it's not being offered for the truth of the matter asserted, if the court believes that, then it would come in. The court believes it's being offered for anything other than what she's saying, that she is using it to prove, or for the proof of matter asserted, then it has to remain out. Did you want to add something?
I did. If it's not being offered for the truth of the matter asserted and it's just being offered for the effect on the listener, then that's not relevant because no one is challenging, to my knowledge, that Mr. Brader did not contact the Attorney General's office. Again, if that were being challenged, then that document might be relevant and it wouldn't be relevant. And Mr. Brader can't say he received this from the National Archives. He can say he received it from an email address purporting to be from the National Archives. I could spoof an email probably in about 60 seconds. So there are all kinds of reasons why this document should not be coming in.
So, Your Honor, the sender, while nominally important, is not really important. The fact is that this document was sent to Mr. Brader and it led to the investigation, because no matter who sent him the document, it's purported to be a fraudulent document. It is not the official certificate of votes for the state of Michigan, which means it has to be investigated, whether it came from a reporter, the National Archives, or from the Republican slate themselves. This is not a legitimate document. So the fact that he received it, and the court needs to see what he received, because facts can't be heard in a vacuum. And it supports his testimony that when I received this document, I knew it was a document that we did not create, and therefore I sent it to the Attorney General for investigation. This is not being introduced to say this was sent to the National Archives and then it was sent to Mr. Brader. Mr. Brader is testifying that I received this and I sent this for, I forwarded this for investigation. And you need to see the document to see why he forwarded it for investigation.
Just so the record's clear, Your Honor, Kathy Burton joins in Ms. Chartier's objections and Mr. Sandler.
I'm just gonna back up a little bit too, in regard to why this is hearsay. Police and prosecutors receive tips all the time. Those tips are not evidence. And they may do an investigation. They have to establish the facts of the case. Why he contacted the AG's office is not relevant. It's clearly, they have to establish the elements of the offense. They're using this to try to establish the fact that this was published to the National Archives. That's what they're using it for. Why a tipster calls a cop or because they've heard something on the street, that is what is not admissible. It's what the investigation leads to following that tip. So this is an improper way to try to establish the quote unquote body of the crime. This is not the body of the crime. He can't testify. It's where the AG says that he knows this came from the National Archives. He doesn't know this came from the National Archives, as Ms. Chartier has already said.
And I agree with that. And the mere fact that a document exists doesn't mean that it's a forged document. Not only is the intent of the signers relevant, but also what happens to the document. I could create a document that says I'm Queen of Michigan. It doesn't mean that I'm really Queen of Michigan. So purporting that this came from the National Archives is improper because, again, there's no one, my understanding of the government's witness list, from the National Archives on the witness list to claim that they ever received that.
The people are not reporting that proposed Exhibit 7 came from the National Archives. The people are purporting that this was received by the witness and that he forwarded the attachment to the Attorney General because it was not a document created by the Department of State and that it needed to be investigated to see if it was a forgery.
Okay, well, essentially is giving testimony that says that there's no dispute as to that. So why do we need the document at this point?
I think the document gives context to why he felt it needed to go to the Attorney General. Now, I can take the email off. I don't have a problem with that, but I think the court needs to see the document to see why Mr. Brader felt that this needed to be investigated as a possible forgery.
Well, the document would still be a part of the email as an attachment. So why would you taking the email that?
No, taking the cover sheet off, which is the email.
Okay. He's already testified he received an unusual document that that caused him to contact the Attorney General's office. Whereby they, I guess, I'm assuming I'm going to learn later, launch an investigation based on that. I don't see why we need the email.
May I respond?
Yes.
I didn't want to talk over the court. Your Honor, we're allowed to corroborate the testimony and also substantiate the testimony. And it is the people's position that the court doesn't get the full context just by hearing, I received a document and I forwarded it on, unless you see the document itself. It's not being used in this instance for the truth of the matter asserted. It's being used to show this is the document I received and I forwarded it on. And later it will tie in with other witnesses, what the investigation was and where that document was sent. But this witness is not testifying to that portion. What he's testifying to is that I received this document and I knew it not to be an official state document. Therefore, there needed to be an investigation. And in order for the court to fully understand the context of this witness's testimony, the court needs to see that document.
For the purposes that you're stating, because I think that this could potentially be used inappropriately if it's going to the truth of the matter asserted, but to corroborate his statement that he received the document regardless of where he received it from, and that this was the document that he sent to the AG's office?
Yes.
Then that comes in. The objection is overruled.
Thank you. Now, Mr. Brader, as to the attachment, did the attachment have a title to it? Like the page itself, not the email.
So not the name of the file, but the name
Not
of the
the-
document?
Yes.
Yes.
And what was the title?
It's initially entitled memorandum. And the subject is Michigan's electoral votes for president and vice president.
Okay. And does that document identify who the votes were, the state, Michigan state votes were tendered to?
Yes.
Okay. And you're looking at what is probably the third page of People's Exhibit 7. Does that have a title on it itself?
Yes.
Third page, you're looking at.
Yes. So the title of the third page is Certificate of the Votes of the 2020 Electors from Michigan.
Okay. And who are the votes for the electors of Michigan tendered to in that document?
For president, they're tendered to Donald J. Trump, and for vice president to Michael R. Pence.
And does that page identify where those votes were allegedly taken?
It says that we convened and organized in the state capitol in the city of Lansing, Michigan.
Does it have a date?
It says on the 14th day of December, 2020.
And is there a signature page attached to that document?
Yes.
How many signatures are on there?
16.
And at the time that you received this document, the electoral votes for the state of Michigan were given to which candidates?
In the
Officially,
they were given to Joseph Biden for president and Kamala Harris for vice president.
permission to publish proposed Exhibit 7.
Yeah, permission granted.
When at this time, people will pass the witness.
Do you need time to see who's gonna go first, or are we gonna go in the same order?
I think it's, again, it's a little bit organized chaos, but I will be happy to kick us off. Mr. Brader, it's unusual, but you've got to turn a little bit to face me. My name is Mary Chartier. I've got some questions for you today. You indicated you started working at the department in 2019.
Correct.
And then you continued on. Are you currently employed there?
Yes.
How many lawsuits have you been involved with as the director of elections, or even when you were what was your title before that?
Before that, my title was legal policy director.
Legal policy director? Is that what you said?
Correct.
Are you an attorney?
I am an attorney. I am not licensed to practice in Michigan.
How many lawsuits have you been involved in?
In my life or?
No, not your personal life, but in your role at the department.
I don't know the exact number.
Can you give us a ballpark?
Including every lawsuit I've been named in or involved in, it's probably over 100.
Because you said in response to the government's question that you've been involved in many lawsuits, so over 100. And you said normally lawsuits are resolved quickly.
I don't believe I said that specifically.
Okay, so then what is the time frame for lawsuits to be resolved?
It varies.
Okay, give us some of that variance, please.
Sometimes lawsuits are very quickly dismissed. They may be withdrawn. That can happen within a matter of days. Sometimes by the time the entire lawsuit is resolved and appeals, it could be multiple years.
And you've been involved in those challenges where they've taken multiple years, correct?
Yeah.
At the time of December 14th, 2020, there were still lawsuits pending challenging the election, correct?
If by pending you mean the lawsuits have not been dismissed, then yes.
Yes, that's what I mean. The
Yes.
lawsuits had not been dismissed, correct?
Correct.
More than one, right?
I believe so, yes.
In state court, correct?
Yes.
And in federal court, correct?
Yes.
This email that you indicate that you received from the National Archives, you said you contacted the Attorney General's office after you received it, and I believe you wrote you received it January 8th, 2021, right?
Correct.
When did you contact the Attorney General's office?
I don't remember the specific date, but I believe I first contacted them shortly after, so either the same day or perhaps the next day.
Did you discuss it with anyone before you contacted the Attorney General's office?
Not that I can remember.
Did you contact any, is there a lawyer for the department?
Yes.
And who is that lawyer?
The chief legal director is Michael J. Brady.
Did you discuss it with him at all?
Yes.
So did you discuss it with him before you contacted the Attorney General's office?
I believe it may have been at the same time, but I don't remember specifically whether I spoke to them at the same time or whether it was for separate conversations.
What do you mean at the same time? So you had them both, for example, on the telephone?
Yes, I believe there was a telephone conversation. I don't remember who was on it.
And so you don't remember who from the Attorney General's office you spoke with?
Likely would have been Heather Beingas.
Is that someone who you'd worked with in the past?
Yeah.
So you contacted the Attorney General's office and then you forwarded the email and the document that you claim that you sent or you were received?
I don't remember specifically whether I forwarded that email. I don't remember specifically how that email got to the Attorney General's office, but I do remember contacting the Attorney General's office.
You know, you talked a little bit about the process, and I think it was Exhibit 5 and 6, which were the 2016 documents or that relate to the 2016 election, correct?
Yes.
On Exhibit 5, do the electors see that document?
I don't know.
Okay, so you have no idea, correct?
I don't know whether the electors in 2016 saw that document.
And you would have no idea, to be specific, if a particular elector saw that document, correct?
That's correct.
And for Exhibit 6, it's a document with words on it, right?
Yes.
And then it has a signature line and someone signs it, correct?
Multiple people sign it.
Multiple people sign it. You have no idea if someone reads that document or not, correct?
I do not.
Would it surprise you that some people might sign a document and not read it?
I suppose it would depend on the person and the document.
Correct. So you have no idea, correct?
I don't know whether those individuals sign that document. I can't speak to the tendencies of every individual to read a document before they sign it.
And would that go for the attachment that you received in 2021 that was purportedly signed in 2020? You have no idea if anyone read that before they signed it, correct?
That's correct.
Now, you talked about the pending lawsuits that existed. And this was a hotly contested election. Would you agree with me?
I suppose that's a fair description.
A lot of people disputed the election in 2020, correct?
I'm not sure what you mean by dispute.
Well, so do you pay attention? You're the director of elections, and then you were the other, what was your other title?
Legal policy director.
Legal policy director. Do you read anything about elections or listen to anything about elections in the news?
Yes.
Specifically as it relates to Michigan's election. Were you following any of that in 2020?
Yes.
And were you following news reports in which people disputed the results of the election?
Yes.
And did you follow that people actually said they had evidence of fraud in the election? I'm not asking whether you agree or not. I'm asking, did you follow news reports about that?
I remember news reports in which people were expressing the opinion that there was fraud in the election. I don't remember, the word evidence. I'm not sure whether I saw articles that were, I can't recall specific evidence in those articles, but I certainly recall people saying that they did not agree with the election outcome.
And are you aware Michigan legislators actually had a hearing in which people came forward, testified under oath as to concerns that they had with fraud in the election?
I do remember hearing, I don't remember whether or not people testified under oath.
Do you remember concerns about Antrim County?
Yes.
And the concerns in Antrim County were that the election voting software actually switched votes from a Republican candidate to a Democratic candidate, correct?
I don't believe that's an accurate description of what occurred, but I do recall people having concerns about the Antrim County election.
Not asking about what occurred, I'm asking about concerns that you heard in the media, correct?
I did hear concerns in the media about the Antrim County election. Yes.
And if that were true, that would be concerning. Would you agree with me?
If what was true?
If votes were being switched from one candidate to another in software, that would be concerning, right?
Again, it's a phrase, if votes were being switched in software, I don't think it's an accurate description of what occurred. So I couldn't speak to that. If something like that actually happened, I suppose people could be concerned by that, yes.
Well, you're the director of elections, right?
Yes.
Wouldn't you be concerned if I went and voted put my vote in there for Kermit the Frog and then it got switched to Miss Piggy? I mean, wouldn't that be concerning if votes got switched?
And I'm gonna object, that's a little argumentative.
I do think he didn't answer the question. And so I'm going to allow it because the question was, would it be concerning? Not what actually happened. So this is a hypothetical.
Correct. That Kermit and Miss Piggy are not running as far as I know.
So if the objection's overruled.
If votes were actually switched, that would be concerning, yes.
Yeah. And there were lawsuits again challenging the election, correct?
Yes.
And that those were pending, meaning they had not been dismissed as at least some as of December 14th, 2020, correct?
Yes.
Now, let's say one of those lawsuits had been successful. There had been a switch in Michigan from President Biden to former President Trump. What would happen then? What's the process for the Republican electors to then have their votes counted?
Well, that was something that a court would have to decide. If the court determines, it would depend on what stage in the process the court determines that something should be changed, but I presume then the court would order the appropriate entity to take steps to effectuate the ruling.
So has that ever happened in Michigan before?
Courts have ordered election officials to change their determinations. I'm not aware of something like that happening with the Electoral College.
Is there a clear process? Because it sounds like there isn't. Is there a clear process for how that would have proceeded?
Well, again, that would be up to the court, and it would depend on the timing. So, for example, if the court were reversing a decision of the Board of State Canvassers, presumably the court would order the Board of State Canvassers to take action consistent with its ruling.
So you said presumably, though, you don't know, right, what would have happened or how it would have unfolded, correct?
Correct.
Now, you talked about the votes need to occur at the Capitol. Is that what you said?
Yes.
Now, what happens if the Capitol is somehow flooded and no one can get in? Then what's the backup plan to that?
I don't believe we've experienced that, at least certainly not in my time. So if the actual Capitol building were unavailable, I suppose multiple state authorities would convene to determine the appropriate meeting location.
And so there's no clear path as to how that would proceed, correct?
I'm not aware of anything of that nature.
The way the voting occurs with the electors, is that solely Michigan law, or does some federal law impact that as well?
It's also impacted by the Electoral Count Act, which is a federal law.
The email you received, did it mention anyone's name in the body of the email? Other than yours, for example?
Which email are you referring to?
Which was Exhibit 7.
In the body of the email. I believe the body of the email referenced the governor. I'm not sure if it referenced the governor by name.
Okay. Now, this gentleman is John Haggard right here. Have you ever met him before?
I don't believe so.
Have you ever communicated with him to your knowledge?
Not that I can remember.
You have no knowledge of what Mr. Haggard did or did not believe when he signed a document in 2020, do you?
I do not.
You have no idea what Mr. Haggard may have been told before he was signing that document, correct?
Correct.
You have no idea of what Mr. Haggard thought would happen to that document, correct?
Correct.
And then you indicated about the electors casting their votes. How are they, do you know, like who calls it and says Michigan is going to President Biden?
Well, the Board of State Canvassers certifies the results. So they complete the canvass, they determine whether, in this case, Biden or Trump had received more votes in the respective counties. And then based on that, the Board of State Canvassers certifies the results, including the electors who were duly elected.
Was that a smooth process this time, or was it a disputed process? By meaning, did people have a lot of opinions about that?
People had a lot of opinions about it.
Did people express some of those to you?
Yes.
Did you get a lot of emails and letters and calls about that?
Yes.
One moment, please. Take your time. I have nothing else. Thank you, sir.
Operator, are you familiar with the safe harbor deadline?
Generally, yes.
And generally, what is that?
That's a deadline that's provided in the Electoral Count Act by which if a state's, and forgive me if I don't exactly quote this correctly, but if a state's electoral votes are determined or the process concluded, that Congress has to honor those results.
You're aware of the 1960 presidential election?
I am generally aware of it.
And you're aware of what happened in Hawaii during the 1960 presidential election?
Not in detail, no.
Are you aware that by the safe harbor deadline, Hawaii had already certified, correct, for the Republican electors?
I don't know.
You're the director of elections, correct?
For Michigan, yes.
And what do you know about the Hawaii 1960 presidential election?
Your Honor, I'm gonna object this relevance.
What's the relevance?
Your Honor, for one thing, this witness already testified that he knows about election law and he knows how presidential elections are handled. The 1960 election is very important regarding the Hawaii allocation of their votes. in that situation. I expect if somebody is director of elections for a state, he would know that Hawaii, by the safe harbor deadline, had been certified for the Republican electors, but it was not the Republican electors who votes were counted.
Okay, so what is the relevance? I'm not disputing that that wasn't an important election, but what is the relevance to this case, though?
There are two. Your Honor. One has to do with the witness's understanding of election law and presidential elections specifically. Two, it has to do with whether or not the door is closed. He's testified earlier about whether or not a determination regarding allocation of electoral votes is final. According to the witness here, that seems to have been final upon the safe harbor deadline. It's not the case historically, and I want to expand upon that.
Your question was whether or not he was familiar with the safe harbor deadline?
I asked that. He is familiar with that generally.
And you were following up on that?
Yes, Your Honor. And I'm asking specifically about what happened historically during the safe harbor deadline.
Your Honor, I renew my objection as to what the 1960 case in Hawaii has to do with Michigan law in 2020. The facts are not on point.
The facts are very, here we have an election where there was a question about whether or not the electoral votes were going to go to the Republican electors, the Democratic electors. The witness is testifying as if that was all said and done by the safe harbor deadline, when historically that's not been the case. Going back to 1960, that is directly on point. And I want to ask this witness questions about that. He has stated, and he is essentially being held out as an expert witness on presidential elections. I want to ask this witness about this.
I don't think he's being held out as a expert witness, but to the extent that it goes to his credibility, I'll allow you to ask the question.
Your Honor, may I make one note?
Yes.
The difference between Hawaii 1960 and Michigan 2020, there was a recount in Hawaii. There, as this witness has testified, there was no recount in Michigan, therefore that's not relevant.
I'm sure there's lots of differences, but I'll still allow him to question him on that.
Thank you.
You're welcome.
So by the safe harbor deadline in 1960, Hawaii had already certified for the Republican votes, correct?
I don't know.
And do you know which way the state of Hawaii eventually cast its votes before Congress and the vice president?
I do not.
You claimed that a court would need to reverse the state certification, correct?
I believe I said if somebody disagreed with the legal determination of the Board of State Canvassers, then they could seek remedy in court. Yes.
I believe you specifically said it would be required for a court to step in, right?
Well, step in what context?
I'll ask the question a different way. Is a court the only body? Is that the only mechanism that could reverse the certification of a presidential election in the state?
I believe so, yes.
You're familiar with the U.S. Constitution?
Yes.
And what the U.S. Constitution has to say regarding the counting of electoral votes?
Generally, yes.
And are you familiar with the U.S. Constitution granting full authority to state legislatures on the allocation of those votes?
I'm not sure what, I don't know whether that specific characterization is correct. I'm not familiar with the exact text regarding state legislatures electoral votes.
Are you generally aware that the U.S. Constitution states that the determination on electoral votes is granted to state legislatures?
Again, I'm not sure that I would agree with a specific characterization of what the constitutional language means other than the language itself.
Okay, then I'll ask specifically. Does it state that the allocation of electoral votes is left to state legislatures? I'm not asking what that means, just whether or not it says that.
I don't know whether or not that's the exact text of the Constitution.
Does it state state legislatures?
I believe that the phrase state legislatures appears in the U.S. Constitution.
Does it say courts or any other mechanism?
I don't know.
Isn't it possible that a state legislature could reverse the certification at the state election?
In Michigan or in general?
Generally in the United States under the Constitution.
I don't know what the Constitution would provide for in the absence of individual state legislation. On top of that, I couldn't speak to what could be possible.
So just to clarify, the Director of Elections for Michigan 2020 does not know for sure, correct?
I'm not a judge, so I don't interpret the constitutional language in terms of what's possible.
That's not what I asked. I'm just asking if that the director of elections positions, we don't necessarily know
We don't necessarily know what.
whether or not the state legislature could decertify the votes allocated for the electoral college by the individual state.
I can't give you a legal determination on that.
Okay, thank you.
You testified that you saw a page.
I believe it was exhibit 7. Was this the page you were talking about? At the top, it says certificate of the votes of the 2020 elections from Michigan. You testified earlier that this was something that you saw that claimed that Donald Trump won the electoral votes for the state of Michigan, correct?
I did read a document that stated that.
Okay, and you said there were a number of signatures on that document, correct?
Yes.
Now, isn't it true that those signatures were on a separate page, correct?
That's correct.
And do you recall reading what was on the page with the signatures?
Yes.
And do you recall anything being on that page other than names and signatures?
I don't recall whether there was something on that page other than names and signatures.
Your Honor, may I approach the witness to
Okay.
Do you want me to
refresh
hand
his
it?
recollection, please?
There's an exhibit here, though.
No. Can you use the exhibit?
Yeah, we can take that back. We actually have an exhibit up here. All the exhibits are here. Which exhibit did you want to show them?
So I believe it's exhibit 7, right?
And you're asking this for refreshers recollection?
Yes, Your Honor.
Signature page?
Yes. And this was the document you were, it's page 2 of the document you're testifying about, Your Honor.
That's right, yeah.
Okay, now that you've had a chance to refresh your recollection, at the top of that signature page, does it say anything regarding what those signatures are agreeing?
It says, in witness whereof, we the undersigned have hereunto in the city of Lansing, in the state of Michigan, on this 14th day of December 2020, subscribed our respective names.
So essentially, this page just says that they sign their names on this page.
It, in witness whereof appears to be referring to something.
This page makes no reference to a page 1.
There's no reference to a page 1 in this document.
There's no reference to the statements on any other pages, correct?
Well, other than the phrase in witness whereof. That would, to me, appear to be the only language here that refers to an external page.
Is there a page 2 at the bottom?
There's no page number on this document.
No further questions, Your Honor.
Thank you. Nicholas Reagan, and Sean Maddox. Mr. Bader, are there procedures where if there was found to be election fraud, if the other candidate did actually win a state, what would the procedure be to rectify that?
So it would depend on, so when you say election fraud, I think you're referring to some sort of illegal conduct with respect to the election or ballots or something that involves the process. That's not a good question. There's a couple of ways that could be addressed. So one is that if the candidate believes that there was fraud or error in the counting of the ballots, they can request a recount. And so the ballots can be recounted. And that again can happen after the Board of State Candidates meeting. Candidates can also, or anyone who believes a crime was committed, can refer any alleged illegal activity to law enforcement. They can then investigate that. And then individuals, if they believe there was some other legal error in the election, again, can file a lawsuit and seek to have a court reverse an election official's decision with respect to the election.
In your work, there's never been, have you ever experienced an election being flipped back to the other candidate?
I believe there have been There have been recounts. I am not specifically remembering whether any changed an election outcome, but that's certainly possible.
In a national election, have you ever experienced this?
National election meaning the presidential election? Not in Michigan.
You know about it in other states.
I'm aware of recounts in other states. I can't specifically remember in instances where the state's presidential result was reversed in a recount.
If there was a reversal, wouldn't the other slate of delegates be necessary for the electoral votes?
That would depend on the state procedure in federal law, but in a presidential election, the electors cast their votes for president.
Yes, so if the other candidate had found the opposite candidate had found to be a state, or a different party had found to had actually won the state, their electoral votes would be necessary to be sent to the National Archives.
Well, I mean, I can only speak to the process in Michigan with any detail, but in Michigan, the recount would be completed prior to the electoral college, to the electors meeting to cast the ballots. So if the recount, for example, in 2020, they're going to recount and determine that Donald Trump had received more votes, then the Board of State Canvassers would have met and certified those electors as duly elected following the recount. And then those electors would have then presumably cast their ballots for Donald Trump.
Are you saying that once votes are certified, it is impossible that there was fraud that the other candidate could have won?
I don't think I said that.
I'm asking, is it impossible once votes are certified, that no matter what is discovered in the future, it is impossible for an election to flip?
Well, so a recount would happen after certification. So certainly a recount could reverse the results of the election, yes. And additionally, as I referenced, if the court were to make a determination that the result was incorrect, that could also, the court would have the authority to effectuate their decision.
And if that were the case, the other party's delegates would be needed. Their votes would be needed.
The process would be that the electors would meet to cast their votes for president and vice president.
Now, if you receive mail by just somebody declaring to be the president of the United States, is that something you would take seriously?
Depend on who it was from.
We received it from John Doe claiming I'm the true elected president of the United States. I mean, would you take it seriously?
I guess I don't understand what you mean by take it seriously.
If you received a letter like that, would you be deceived in believing that John Doe is president of the United States?
I would not. No.
You testified that what was concerning from the National Archives was that the votes they received were not submitted by the governor.
Correct.
And what is the legal significance of that?
Well, our state law lays out a detailed process by which we determine who won elections and who lost elections. In this case, after spending months preparing for, working with local election officials across the state to conduct the election, overseeing that election, having 83 county canvases canvass the results of that election, having the Board of State Canvassers canvass and certify the results of that election, and having seen the electoral college process, I was well aware that under the procedures that Michigan uses to determine who were duly elected as electors, I knew who those people were, and I knew how they had been submitted. And so this document seemed notable to me in that there was another slate of individuals who are claiming to be duly elected electors to president of Michigan.
Okay, but you were not deceived that they actually were.
I did not believe that they were the duly elected electors.
And back to my last question, if you received a letter from just a John Doe claiming to be president of the United States, you said you would not be deceived by something like that. In that scenario, would you submit it to the Attorney General?
It would depend on the context. I don't know what I would do.
Would it depend on the legitimacy of what you received?
I mean, in the course of my work, I'm not sure what official capacity I would receive a letter from someone named John Doe claiming to be president of the United States. So it's hard for me to speculate as to what I would do with that. If I believe that there had been some kind of potential violation of the election law or something that needed to be investigated, I would refer it.
Was there any communication with the governor's office regarding the email, what you had received?
The email from the National Archives?
Yeah.
That email was also sent to Mark Totten, who at that time was in the governor's office.
Did you know at the time, Michonne Maddow?
No.
You know her husband, Matt Maddow?
No, I do not know him.
Are there, so you submitted, you reported the email that you received to the Attorney General. I'm wondering, are there any official policies or procedures in place on, is that the official policy procedure on what to do if you receive irregularity? Or is there some other policy or procedure?
I don't think there's a written policy or procedure that determines how we, how I or the Bureau of Elections would refer things. But generally speaking, if we think that there has been a possible criminal violation or something that needs to be investigated that's of legal significance regarding the election law, we will contact the Attorney General's office.
I have no further questions.
Yep, you might want to come up that side, then at least you can get close to the mic.
Very good. Good afternoon, sir. My name is Paul Staplin. Ms. Chartier had asked you questions earlier about your experience with lawsuits. You remember those questions?
Yes.
Okay. And in regard to she brought up with you the Antrim County matter, correct?
Yes.
Okay. And you were aware of that going on in 2020, right?
Yes.
And a lawsuit had been filed in regard to that case, correct? In regard to that county.
There was at least one lawsuit that was filed in Antrim County, yes.
Okay. And you were also aware at the time in 2020, not only the state lawsuit that had been filed, or maybe there were other state lawsuits that you know of, but there was federal lawsuit also filed, correct?
Yes.
Okay. And that was filed in the United States District Court in the Eastern District of Michigan, correct?
I believe so.
Okay. And on December 14th in 2020, are you aware of the fact that that federal lawsuit had not been dismissed and it was still pending as of that date?
I believe it had not been dismissed as of that date.
Okay. And do you know that it was dismissed sometime later in the beginning of January? Is that your understanding, or do you know?
I don't remember what date it was dismissed.
Okay. And Ms. Chartier had also asked you a number of questions about the contested nature of the 2020 election. You remember those questions?
Yes.
Okay. And you indicated earlier that the procedure is that each county has their own board of canvassers that will certify the number of votes for each candidate, correct?
Within the county, yes.
Within the county. And is it correct to say that then they transmit their conclusion to the state board of canvassers?
Yes, through the Secretary of State, but yes.
Okay, all right. They send it to the Secretary of State, Secretary of State then sends it to the State Board of Canvassers, is that correct?
Correct.
Okay. And then it is the State Board of Canvassers' responsibility to review what's sent to them and then make a decision as to whether or not they're going to certify the election statewide. Is that correct?
I think that's accurate.
Okay. And the State Board of Canvassers is made up, I think you said earlier, of 2 Republicans and 2 Democrats. Is that correct?
Yes.
Okay. And the is the law in Michigan that the State Board of Canvassers has to have a unanimous decision in order for the election to be certified?
No.
A majority carries out of the 4?
Yes.
Okay. You talked about the election results in 2016. You identified some documents from 2016, correct?
Correct.
And in regard to the certification by the State Board of Canvassers, the vote was 4-0 to certify the results. Is that correct?
I believe that's correct.
Okay. And in 2020, that it was not 4-0 in regard to the certification, was it?
That's correct.
One of the certification occurred on November 23rd, 2020. Is that correct?
Yeah.
And on November 23rd, 2020, one of the members of the State Board of Canvassers had abstained from voting. Is that correct?
Yeah.
And so the result was 3-0 as opposed to the unanimous vote, correct?
Correct.
Okay. You testified earlier on direct examination that you had received, or I'm sorry, you received this email and then you contacted the Attorney General's office, correct?
Yes.
And I'm sorry if I missed it. When did you contact someone at the Attorney General's office?
It was shortly after. I don't know if it was the same day or the next day, but shortly after.
How did you make that communication?
I believe it was a phone call.
Okay. And you said you believe that you called Heather Meiningas, is that correct?
Correct.
Is she someone that you have worked with before?
Yes.
Do you know what division or unit with the Attorney General's office she is assigned to?
I'm not sure what the name of the division is.
Okay.
I think it's like civil litigation. I don't want to get it wrong. She's the attorney.
In your mind,
yes.
it's a civil litigation.
Yes.
Part of the office, correct? Not criminal.
Yes.
Okay. You recognize the difference, correct?
Yes.
All right. Nothing further.
Ray, you downplayed your ability to understand the law just a hair. You're Columbia educated graduate for your undergrad, correct? Is that a yes or no?
Don't agree that I underplayed my ability to understand the law.
Okay, just answer. Where'd you go to your undergrad?
Columbia University.
Where'd you go to law school?
University of Michigan.
And you are or were licensed in the state of New York to practice law?
I am currently, yes.
Okay, are you licensed anywhere else?
No.
Been licensed in DC?
No.
You would agree with me that the U.S. Constitution, Article 2, Section 1, creates the federal position of President of the United States and Vice President, correct? And if you can't remember I have the statutes, I have the Constitution, and I can refresh your memory with them if you'd like.
I'm not going to agree with a specific phrasing of any constitutional language without looking at it, but I agree that Article 1, yes.
Okay, so you agree but don't agree, or you do agree?
I can, if you want to
The
provide.
question was,
specific
does he
language.
agree that that's what the article says?
That the offices of the presidency and the vice presidency are established, created by Article 2, Section 1 of the US Constitution.
I believe that's correct.
And that same provision sets a 4-year term for president, right?
Again, I believe so.
If you don't know, again, I can refresh your recollection. It also dictates that each state's legislature is to promulgate rules and laws to determine the presidential electors for the Electoral College. Agreed?
Again, I don't remember the exact wording of the Constitution of the United States. in there.
We'll see if legislators is in the Constitution. Legislatures. And Coach Ron?
Are you asking him, will this document that you're gonna show him is going to refresh his recollection?
Yes, Sean.
Okay, what is the document you're gonna show
It
him?
is a Westlaw printout.
Do you wanna show?
I will.
us?
It's not moving for a minute, nothing, so just want to refresh his recollection on the law. If the Constitution sets or encumbers the state legislatures to create laws and rules to determine the presidential electors from those states for the Electoral College.
I'm gonna object to the relevance of going through the United States Constitution, any of the articles. We've already talked about the state statutes that govern election law in the state. I fail to see the relevance of this.
What's the relevance?
The relevance is, Your Honor, that this line of questioning into both the US Constitution and the Electoral Count Act prior to its amendment, I believe, December of 22 or 3, will establish that what my client, Kathy Burden, is accused of is not a crime under state law. It's governed by federal law. The Attorney General was told that not only by the Ingham County Prosecutor's Office, but I believe the U.S. Attorney for the Western District Office. And it just so happens, Mr. Brader referenced Mr. Mark Cotton, who used to be at the governor's office as chief legal counsel. He is now the U.S. Attorney for the Western District of Michigan. He knows, I assume, because he reports to the governor or to the Attorney General on behalf of the governor that supposedly there could be criminal activity here as chief legal for the governor. He's now U.S. Attorney. This is in his district. The alleged acts took place in his district. He has yet to charge anyone with a crime. And I think it's because federal law very clearly mandates this is federally controlled. The state of Michigan, in addition to charge election law forgery, and we'll get to that, it's got to be a document described in the Michigan election law. We will then go into the fact that the Michigan election law refers to MCL 168.1 et sec, meaning that code, and nowhere in that election law, I assume Mr. Brader is going to say that a certificate of votes is described in that election law. It's all federal law.
I think there's gonna be some joiners.
I join with Mr. Coger. Also, what is extremely relevant, of course, the United States Constitution is relevant in every case, but also whether these are state versus federal functions for the Republican electors is absolutely relevant and will be relevant to the arguments against bindover.
Marion Henry joins, and I believe we already addressed this issue.
Paul Stavlin, I joined as well. So. Nicholas Sommer, you join.
Yeah, and the United States and the state of Michigan are separate sovereigns. So the United States attorney's decision not to pursue charges has no bearing over whether or not the state of Michigan chooses to address laws that may have been broken in the state of Michigan.
I don't have any knowledge as to whether or not the United States attorney for the Western District has intentions of charging defendants or not. In this case, that's not before me. But I do think that this line of questioning does have some relevant bearing on the case at hand. So the objections overruled. You
Thank
can
you,
refresh
Madam
his
Mayor.
record- Yeah, you can refresh his recollection.
Once again. Wrong, document. To your honor before.
Oh, it's not an exhibit though. I thought you were just refreshing his
Yeah,
recollection.
yeah,
Yep,
go
I don't
ahead.
need to see it.
Take your time.
Then we may need you to repeat your question another time.
Sure, Your Honor.
Okay.
So the question again, just for the record, and there's been a lot of talking since then. The Constitution dictates that the state legislatures are to promulgate rules and laws to govern how presidential electors are to be selected within the states, correct?
So you're referring to Article 2, Section 1?
It's on the, I believe it's on the 2 pages, one of the 2 pages that I just gave you.
Sorry, what specific section of the Constitution are you referring to?
I believe it's Article 2, Section 1, the president.
And you're asking me if it says what?
Are the state legislatures required to establish laws and rules on how presidential electors for the Electoral College are selected from each state?
So Article 2, Section 1 says, each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives to which the state may be entitled to Congress, and no senator, representative, or person holding an office of trust or profit under the United States shall be appointed and elected.
Okay. And would you agree with me that the state legislature sets those rules on how electors are to be selected? Is that what that says in layman's terms?
I can't speak to a specific interpretation of the United States Constitution.
Mr. Brader, you're a very high ranking member of Michigan's executive branch of government. You are charged with carrying out the laws of the state of Michigan, which also fall under the umbrella of the U.S. Constitution. Is it not true that every single day you are reading rules, regulations, laws, administrative rules, so on and so forth, and applying them to certain scenarios?
I would say I do that frequently. I don't know if I do
Okay,
it
I'm not
every day.
asking you to enter an opinion binding on any court in any court matter. I'm asking you, as a very high-ranking executive officer of Michigan's executive branch of government, does that document, the U.S. Constitution, require the state legislatures to promulgate rules and laws on how electors from the state are selected for the Electoral College?
So the exact phrasing here is, each state shall appoint in such manner as the legislature thereof may direct. You've added some language to that. And
Okay.
I'm not
Sure.
qualified to
Got it.
interpret that on behalf of the state of Michigan.
Thank you. The idea, you would agree with the Electoral College, is it's really the framers' way of ensuring that, supposed direct democracy, or in other words, mob rule, doesn't dictate the outcome of the presidency, right?
You're asking my opinion
Yep.
about the basis for the creation of the Electoral College?
Yes.
Karen, I'm gonna check this relevance.
What's the relevance?
Well, the Electoral College, and I'll get to this later, but the Electoral College fractures the power of each state to impact the presidency based on the outcome of the elections in each state. And, frankly, even if these events were to take place, even if Vice President Mike Pence were defrauded for the state of Michigan, it would not change the outcome of the presidential election. I want to know, I'm sorry, Your Honor, I didn't mean to cut you off.
Okay.
I want to know if Michigan's director of the Bureau of Elections knows the function of the Electoral College. It's relevant. They're charged with supposedly forging what's called a certificate of votes, which is a document required under the Electoral Count Act, which is its only function is to serve in the Electoral College. That's why I'm asking if he knows what the Electoral College is and why it was created.
And I don't think that's relevant. The reason we're here is for a forged document. It just so happens to be a forged document under election law. So the history lesson is not relevant as to the reasons that our founding fathers promulgated the Electoral College.
Well, this question was, does he understand what the Electoral College does? Or
Right, what it's for.
what it's for, what the purpose is for. The allegation, or I guess the underlying allegation is that there was a document forged representing a separate set of electors. So how is this not relevant?
The history of the Electoral College?
No, he's not asking the history, I don't think. I think he's asking, does he understand the purpose? He's got to give us the history.
Oh, the question I objected to was in asking the historical purpose of the Electoral College. That's what I object.
Whether or not he knows this, the purpose, the historical purpose, I'll allow him to answer. We're not going to get into what the historical purpose is.
I won't start quoting
Or refreshing recollections about it, but I think that we do need to know if this particular witness, based on his testimony that he received a document and because of his concerns about the unusual nature of it, we would need to know if he understands the Electoral College or he has an understanding. What caused him to do what he did? I think that's relevant.
I agree with that, with the court's assessment, that was not the.
That was my understanding
this
of,
question.
maybe he rephrased the question when I asked, I'm not sure, but I like the way he rephrased it if that's what happened. So we'll go with that. You can answer that question.
I'm sorry, what is the question?
The function of the Electoral College, generally speaking.
Yeah, sure. Generally speaking, we don't have a single national election. So the function of the Electoral College is to compile each state's electoral votes for president, tally them and determine who is president and vice president based on the count of the electoral vote.
And that's to determine, or to ensure, I would say, I would think you would agree with me, that no one state or three states necessarily control the outcome of the presidential election.
I'm sorry. Can you speak up? Can you repeat that a little louder?
That's to ensure, I believe Director Grader would agree with me, that no 1, 2, 3 states dictate the outcome of a presidential election.
It's certainly correct that 3 states cannot determine the result of the presidential.
Are you aware of any scenarios where, in fact, not every state had their electoral counts voted? Or I'm sorry, counted?
Historically, I'm not sure.
So if I were to tell you that it happened sometime in the late 19th century in Wisconsin, due to a snowstorm, that wouldn't ring a bell?
No.
The Electoral College also represents the fact, I think you would agree, that the United States is a representative republic. It's not a true democracy despite any political punchlines.
You're asking my opinion as to whether.
I'm not sure I understood what was the
I would
question?
like, I would like to know if the director of the Bureau of Elections understands what kind of government the United States government is.
Objection, no.
It all goes back to the US Constitution, where these offices are created, how they're selected, what the function is. And as somebody who testified previously that he came in 2020 and oversaw a federal presidential election, I think it's very relevant to know what he, as director of the Bureau of Elections, knows and doesn't know as it relates to a federal presidential election when he is driving the bus you're on.
Well, he doesn't preside over a federal election. He presides over a state election of a president. He only presides over what happens with the Michigan votes. What happens federally, nationally, has nothing to do with this witness, and we're getting far off topic going down this road.
Will you join in this objection?
Well, Counsel for Mary Ann, this is directly within the scope of the direct examination. People specifically asked this witness if he knew how presidential elections work. He then went on to explain them. This is cross-examination right on what was asked during direct.
And I would add, specifically, the US Constitution was referenced on direct, and so was the Electoral Count Act. So it was open, they opened the door to it, and now, because candidly, I think it hurts the Attorney General's position, they don't want us asking questions about it.
We don't know what the answer is. We don't know if it hurts their position.
It does not hurt my position. It's just not relevant.
I'm joining in Mr. Cover's line of questioning in his response to the objection, but also the Attorney General's office asked this court to take judicial notice of various statutes related to election law. I think following what the Constitution and what that says about elections is certainly relevant on cross-examination.
We're not talking about the Constitution right now, though.
Or the constitutional process.
Your Honor, I can move on. I mean, it's in the record. We can argue it later. The Constitution applies, as Ms. Chartier already stated, to every criminal case in the United States.
And there's no president of Michigan, right? So he is the president of the United States. So how Michigan reacts to that election is most certainly relevant.
I agree. You can proceed with your question. The objections are ruled.
Then in that case, you would agree the United States under the federal Constitution was created as a representative republic, not a direct democracy, despite any political punchlines. Yes or no?
I don't believe that I can accurately answer that question, yes or no, because it includes an opinion about what a representative republic is and what a direct democracy is. I understand direct democracy, as you say, to refer to a system in which everybody votes on everything, which is certainly not the system that we use in the United States. I think people disagree as to whether or not a representative republic is a type of democracy. I'm not a political scientist. My understanding is that democracy also is used broadly to refer to systems of government where people choose their elected officials and choose who makes their laws. So in that sense, like a representative republic is a type of democracy. That's my personal opinion. I am not a political scientist.
All right. So in that vein, your personal opinion as director of the Bureau of Elections, what kind of government does the United States have?
We are a federal system. I would call it a representative democracy. I think that's the most accurate description of our system.
Constitution mandates that the chosen presidential electors meet and cast their votes by ballot for president and vice president, right? Same provision you just read.
I believe that's what it says.
Okay. sort of alludes to, and I can let you reread it, something called a certificate of votes. Would you agree or disagree?
I don't recall whether the phrase certificate of votes appears in that section.
I'll represent to you that exact phrase doesn't. But if it would refresh your recollection, take a look and tell me if something that catches your eye that might reference something like a certificate of votes.
So Article 2, Section 1, and the third clause states, the electors shall meet in their respective states and vote by ballot for 2 persons, of whom one at least shall not be an inhabitant of the same state with themselves. And they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify and transmit sealed to the seat of the government of the United States, directed to the President of the Senate.
What's that?
This is also contained within a clause that is bracketed with a footnote that indicates the clause enclosed in brackets was superseded. by the
Wait, let me, hang on, let me,
Sure.
I should stop you there just for purpose of the record. I don't think that's gonna carry the day one way or the other. But I do want to make it clear, I have presented this to you as solely to refresh your recollection. I'm not offering it as an exhibit. The law speaks for itself. Ultimately, I want to know what you know. But for the purposes of the record, it's not offered as an exhibit, and I don't want you to just read it in as evidence, if that makes sense. So if you want to give an opinion based on what you've read, if your memory is refreshed, then go for it.
Well, there again is a phrase that says number of votes, and they shall make a list of all the persons voted for and of the number of votes for each, which list they shall sign and certify.
Earlier, Mr. Brader, you testified, I believe, correct me if I'm wrong, that the certificate of votes was supposed to go to the National Archives. Is that correct?
Yes.
And if I recall your testimony, and correct me if I'm wrong, you testified that you did not believe or you did not know whether it went somewhere else. Is that fair?
I remember not being certain at the time whether it also went to Congress.
So US Constitution, you just read, it goes to the President of the Senate, right?
That's correct.
That would be you would agree with me, Vice President of the United States. Right?
I believe so, yeah.
Earlier, it was referenced the Electoral Count Act of 1887. Would you describe your familiarity, sorry, with that act?
General, I would say that I understand how it relates to how we transmit our electoral votes.
Not only transmitted, but also, would you agree, counted, how it's counted?
Yes.
Fair?
Yes.
And those votes are counted in a joint session of Congress. Would you agree?
I believe so.
And a joint session of Congress, correct me if I'm wrong, includes the entire US House of Representatives and the entire US Senate. Is that fair?
That's my understanding.
And your understanding is that presiding over the joint session of Congress is the Vice President of the United States, also referred to as the President of the Senate.
That's my understanding.
Now, the Electoral Count Act has been amended since December 2020. Would you agree?
Yes.
And I'm only going to, because only the law at the time was relevant, I'm only going to speak to what the Electoral Count Act in December of 2020, January of 2021 required. The new act, as amended, you would agree with me, is irrelevant to these proceedings.
It wouldn't be have been enforced at the time. So I agree that it does not have any provisions that are new would not have that effect on 2020. Yeah.
I'll ask it this way. You, I presume, prepared yourself to oversee Michigan's 2020 presidential election prior to the election.
Yes.
And as part of your preparation, did you review the Electoral Count Act?
I reviewed it. I don't know. Yeah, I couldn't say in what level of detail, but I did review it. Yeah.
Sure, you reviewed it. And it's fair to say you did not at that time review the Electoral Count Act. Sorry, it's been a long morning already. You did not review the Electoral Count Act that was amended, I believe, in 2022. Fair?
Yes.
And at the time, Congress met. Again, I have all the statutes. We can refresh your recollection. I don't want you to answer if you don't know. But Congress met January 6th to tally the Electoral College votes. That's 3 USC Section 15 prior to amendment. Would you agree with that?
I don't remember the specific section, but otherwise, yes.
If I represent to you that that's 3 USC Section 15, you have no reason to dispute that?
That's correct.
Again, we already went over it, but again, it's laid out in 3 USC Section 15. Vice President Pence presided over the joint session of Congress where they tally the votes. Do you agree or disagree with that?
I would agree.
Vice President pursuant to that same code, 3 USC Section 15, opened, read, and tallied the votes. Would you agree with that?
Yes.
Would you agree with me that only the Vice President of the United States, pursuant to the ECA and the US Constitution, counted and tallied the Electoral College votes from each state?
I believe that's correct.
Is that a yes, you would agree with me?
Yes.
During the 2020 presidential election, I've said his name before, but I believe you would agree with me, that person who was opening and tallying the electoral votes was Vice President Mike Pence, correct?
Correct.
The Vice President would then listen to objections coming from the joint session of Congress to, and I'm quoting 3 USC Section 15. If you don't agree with this, I'll provide the statute to you so you can refresh your recollection. But the Vice President heard the objections to all the certificates and papers purporting to be certificates of the electoral votes. Agreed?
That sounds right to me.
And that would, of course, only happen if objections were made, right? He's not hearing objections that weren't made, correct?
Yes.
So the plain language of the Electoral Count Act as it existed in December and January of December of 2020 and January of 21, the plain language contemplates the possibility that objections could be made at the joint session of Congress and that Congress could reject submitted certificate of votes, correct?
Well, based on the language you stated, you cited, it sounds like, yes, they could raise objections. The second half, I'm not sure I understand the question.
Oh, you're a trained lawyer, right, Mr. Brader?
Yeah.
You know what an objection is?
Yeah.
What's an objection in your opinion?
It's a disagreement noting a point of procedure or law that the objector believes not being administered correctly.
When you make an objection, you're asking the presiding officer over the proceeding to make a ruling on your objection, right?
Generally, yeah.
Agree or disagree with what I'm doing, right, presiding officer, in this case, a court, for example?
Yes.
So if the ECA contemplated objections at the joint session of Congress, to your mind, the second most highest, I believe, the second highest executive officer presiding over Michigan's elections, including a presidential election, that you testified you prepared to administer. In your opinion, what would happen with an objection, generally speaking, at the joint session of Congress?
So my expectation would be that the presiding officer would hear the objection and rule on it. I'm not familiar with the specific procedure by which objections would be disposed of one way or the other in that context.
That's fair. We'll get to that. I can refresh your recollection, but for now, I think that's fair. Just so happens it's right here. At the time, the ECA, the Electoral Count Act, only required one objection from a U.S. representative and one objection from a U.S. senator. Are you aware of that?
That was my understanding, yes.
The procedure after that objection, and again, I can refresh your recollection, was that the Congress would debate the merits of that objection, and which would include certificate of votes, certificates of ascertainment, so on and so forth. Do you agree?
I think it would depend on the nature of the objection, but assuming they apply to those documents, then that would make sense to me.
Did you watch the certificate of, or I'm sorry, the counting of the Electoral College votes by Mike Pence?
I watched parts of it.
Did you watch Michigan's part?
Yes.
And I presume you did that because you're the director of the Bureau of Elections, right?
That was one of the reasons, yes.
What are the other reasons?
It was interesting.
Pretty remarkable time, right?
Yes.
Do you recall if any objections were made to the counting of Michigan votes?
I believe so.
Who made the objection?
I don't recall.
I represented to you, it was a representative, I believe, from Georgia named Marjorie Taylor Greene. Would that sound right to you?
Yes.
Vice President Mike Pence then heard the objection and requested, correct me if I'm wrong, or asked, I should say, if a U.S. Senator would join the objection, correct?
I believe so.
And no U.S. Senator joined in that objection, correct?
I believe that's correct.
And based on your personal knowledge and reviewing that video or watching that video, because it was so interesting and because you're the Bureau of Elections Director, does it stand in your mind, or do you recall whether supposed certificate of votes from Michigan's Republican electors ever was referenced or talked about in the joint session of Congress?
Not that I can remember, but it's possible.
Are you aware that the Michigan supposed alternate electors certificate of votes never arrived to Vice President Pence?
I don't know whether it did or not.
As Director of Bureau of Elections, you didn't find that piece of information important?
You're referring to the
document right
this
in front of you.
document?
Yeah.
It may have been important, but I didn't, I don't recall finding out whether or not that happened.
Whose job was that to find out?
I don't know.
Not the Director of the Bureau of Elections for the state of Michigan?
There's no specific official who is named who's responsible for determining if a alternate document makes its way to the Vice President.
Director Brayer.
The governor submits the certificate of ascertainment to the National Archives. So I do not deliver that document.
I didn't ask you if you delivered. I asked if you ever sought to verify whether it had been delivered. And I mean ever. I don't mean on January 6th. I mean ever.
I don't recall ever doing that.
I think that would be an important function of the chief executive officer over Michigan's elections, including a 2020 presidential election that you oversaw.
Well, I'm not the chief executive officer, just for the record.
Oh, no, let me stop you there, because the record's important. Who is the chief elections officer for the state of Michigan?
That's the Secretary of State.
And that would be?
Jocelyn Duncan.
And does she not delegate her authority over elections to you, the director of the Bureau of Elections?
I have authority to act on her behalf.
Right, and that's because the Secretary of State, as the elected official, has many functions, not just elections. Fair?
That could be one of the reasons why the election law is drafted the way it is, but the election law states that I have the authority to act.
So you do have the authority, right?
Yes.
Okay. So, not to get bogged down in constitutional language, I know you don't want to go there, but for practical purposes, you're the chief executive officer overseeing Michigan's elections, correct?
I don't really agree with that. I mean, the Secretary of State is the chief election official. She is specifically named the chief election official. So I don't agree that I'm, for practical purposes, the chief executive officer.
Fair, okay. But you wield the chief executive officer's executive authority more so than your support staff.
That's correct.
Are you aware that the Attorney General's Exhibit 7, I believe, is what the document as the AG referenced as the body of the crime? Are you aware that never made it to Vice President Pence, number one, but it also didn't make it to the National Archives until January 8th of 2021?
I don't know I don't know the answer to your question. I don't know whether it arrived to the vice president. I don't know when it arrived to the archives, other than what it stated in the email.
For clarification, that email's been admitted as evidence despite objections to it, correct?
I believe so.
Your Honor. The email's admitted, correct? As part of the exhibit?
The email and the attachment was admitted, but not for the proof of the matter, sir.
I see. Well, I'm just going after the date. Says
So it does say today.
today, and
Said you
then
received today, and
is
it's
it-
dated January 8th. So
what time?
the email is 4:37 PM.
Okay. And then your testimony was that you just forwarded that along to Heather Meingast, Assistant Attorney General, because you thought it was suspicious.
I said I contacted the Attorney General's office. I believe it was Heather Meingast, and I believe the initial contact was a phone call. I don't think I said, I don't remember whether I used the word suspicious. But again, it was certainly unusual that a document purporting to be from the duly elected electors from the state of Michigan that were not in fact the ones that the governor submitted and been sent to the National Archives.
And prior to that phone call with the Attorney General's office, did you take any steps to verify the facts of what was being presented to you, or did you just take that and run with it straight to the AG?
I believe again, I contacted, I think it was a phone call. I don't recall doing any separate research to determine what may or may not have occurred before contacting the Attorney General.
Why did you contact the Attorney General's office?
Well, as I stated, it was unusual that a document that was purporting to be the duly elected electors when we duly elected electors in the state of Michigan, and not in fact the ones that were duly elected and have been submitted by the governor were sent to the National Archives.
Fair,
So that raised concern.
fair. But did it raise criminal concerns right off the bat?
I don't remember whether, I don't remember what initially forming an opinion as to whether it was a criminal violation or not.
So you just testified that you're not the chief executive elections officer. Did you take that document first to Jocelyn Benson, your boss?
Not that I can recall.
Why would you not do that?
Generally speaking, I work directly with counterparts, both at the Department of State, in the Legal Policy Office, and with the, or the Legal Office, and the Attorney General's Office as well.
So you didn't identify immediately that it was criminal. It's fair to say the Attorney General's office would be handling this as a criminal matter, obviously, right?
That would be my expectation.
Yet you, as you very clearly made it, a subordinate to Jocelyn Benson, went around Jocelyn Benson straight to the Attorney General.
Yeah, I don't agree with the characterization of going around.
You don't have to agree with me. Well, did you go to her?
Your Honor, I would ask that the witness be allowed to answer this question. I mean, give his answers in complete.
Fair. Sorry, Your Honor.
Okay, the question was whether or not he, in his own words, I guess, being the subordinate to Jocelyn Benson, went around her.
Went around Jocelyn Benson as Secretary of State and instead reported that directly to the Attorney General's office.
Are you able to answer that, sir?
I don't remember when or how the Secretary of State herself was notified of this correspondence. What I remember is directly contacting the Attorney General's office about this. But given the manner in which I do my work on a day-to-day basis, working with other agencies, I don't think it's accurate to characterize that as going around the Secretary of State.
Okay, well, that's fine. But you'd agree with me that you just testified, you saw that document, it was not immediately a criminal, it didn't come to your mind that this was a criminal act, correct?
I don't remember whether I formed an opinion on that question.
But nonetheless, it's odd. Fair?
I said it was unusual, yes.
Sure. And then between odd and not criminal, I won't say you went around anyone, but you went directly to the Attorney General's office.
I contacted the Attorney General.
Okay. You did not go prior to the Attorney General's office. You did not take that document to Jocelyn Benson.
Not that I can remember. As I said, it's possible that I discussed it with Mr. Brady, the Chief Legal Director of the department, but I don't remember whether that conversation happened before contacting the Attorney General's office or simultaneously.
Okay. So back to the Electoral Count Act, as it existed prior to its amendment, as it existed back in, I have the date of the amendment, I'm sorry, it was December 28th, 2022. So the Electoral Count Act prior to December 28th, 2022, before the Vice President of the Senate, I'm sorry, the President of the Senate, the Vice President of the United States could count the Electoral College's votes from each state. It required 2 documents. Would you agree?
From Michigan or in general?
From every state.
I believe it would require I think that's correct, yeah.
Okay, those 2 documents you would agree with me are number 1, a certificate of votes. Right?
Yes.
The second document required before a certificate of votes can be counted is called, and it's already been referenced several times in the record, a certificate of ascertainment, correct?
Yes.
So I want to talk about the certificate of ascertainment a little bit. It's in the record, I can present it. I.
They're right here.
Oh. I'll just use both. 2016. This is. Giving you two documents, Mr. Brader. One is, so the record's clear, we're dealing with copies of the certificate.
That's their exhibit. What's exhibit number? It's on the back.
People's Exhibit 3 and People's 5. And so the record's clear, those are copies of the certificate of ascertainment. They are not the originals, correct? Correct. And those are stored publicly available documents by the National Archives, correct? You know that?
I don't know that for sure, but I imagine they are.
Okay. Are they stored by your office and publicly accessible?
We retain a copy of them.
Could anybody get a copy if they wanted them?
I believe so, under a public records request.
Okay, so like a
Unless there was some
FOIA or something?
exception that I'm not aware of.
There's
at this time.
no internet accessible thing like there is with the National Archives to get this from your office. Is that fair?
Not as far as I know.
Okay. So both certificate of ascertainments, call them elements, they have certain characteristics. They're signed by the governor, agreed?
Yes.
They bear the state seal, the state of Michigan's official seal.
Yes.
They bear the names of each elector.
Yes.
And as you testified before, they have the official results of the popular vote as it relates to the presidential electors, correct?
Yes.
And it is incumbent on the governor of the state of Michigan, who at the time and still is Governor Gretchen Whitmer, to inform Congress, joint session of Congress or US Congress, I should say, of the final results of all the legal challenges to the appointment of the electors as reflected on the state's certificate of ascertainment. Is that fair?
I'm sorry, you said the legal what?
The results of the legal challenges. I can show you the statute.
I'm not familiar with that provision. I'm not remembering it. I think
Have
there's
you-
reference to legal challenges.
But you've read, you testified earlier, you've read the Electoral Count Act?
I have read it, yes.
One moment. I'm gonna leave that there for your reference. If you would take a minute, review it and see if your memory is refreshed as to the governor's duty to inform or produce certificate of ascertainment. All right, is it fair to say that the executive officer of the state, which the chief in the state of Michigan is the governor, is encumbered by the section 6 of the ECA to carry out certain duties as it relates to reporting the certificate of ascertainment to the joint session of Congress?
Yes.
We already hit on it, but I just want to be clear. The certificate of ascertainment, certificates of ascertainment, and the certificates of votes are all publicly available on the National Archive website. Would you agree?
I believe that's correct, yeah.
And again, it's a section 6 requires the governor of the state to mail the certificate of ascertainment directly to the president of the Senate, again, the vice president of the United States, and the National Archives, correct?
So the first duty that's listed here refers to sending.
Again, it's just for your memory. If you disagree based on reading that the governor doesn't send the certificate of ascertainment to the president of the Senate, that is perfectly fine. The law speaks for itself. I'm after what you know as director of the Bureau of Elections.
So my recollection, as I stated, was that it was sent to the National Archives. And then I wasn't sure whether it was also sent to Congress. But looking at the correspondence, I believe it also does go to the, well, this just lists, this letter is just directed to the National Archives.
But you were going to say you believe it does also go directly to the president of the Senate? Director Brader, were you involved in creating the 2020 certificate of ascertainment at all?
I didn't draft it. I may have reviewed it.
Were you involved with creating it at all?
Creating it, no.
Were you
But
involved
I may have reviewed it.
in presenting it to wherever it was going? Review would be involved there?
Yes, I reviewed it.
And why would you review it?
Because the work that was done on the drafting was done by field election staff.
And you're making sure the law is complied with, correct?
Yes.
And you would agree with me that the certificate of ascertainment is crucial to the function that the Vice President of the United States, the President of the Senate, has in counting and reviewing, tallying the Electoral College votes in the joint session of Congress, right?
The Vice President needs to have that information. Yeah.
That information being certificate of ascertainment, number 1, from the governor, certificate of votes, number 2, from the electors. Right?
Correct.
It's a belt and suspenders approach. Would you agree?
I don't really understand what you mean by that in this context.
Okay. Refer to exhibit 7, please. I believe it's that. I have my statute knife too. Thank you. Isn't it true that exhibit 7 explains that the certificate of votes would not go to the Electoral College because it did not come from the Michigan Secretary of State?
Email states that because this did not come from the Michigan Secretary of State's office, we will not be adding the documents to the Electoral College website.
Let's turn to the certificate of votes. Again, as ECA required prior to December 28, 2022. Sorry, can't approach one. Right, I'm gonna present him with People's Exhibit 6 and People's Exhibit 4. Fair, we would agree that 3 USC section 9 speaks to and creates the certificate of votes, correct?
I believe so.
So, or is that correct?
I don't recall the exact section, if that's.
Okay, I approach your honor to refresh the memory.
Yes.
Take your time. I don't want you to read it into the record. It's not an exhibit. Just refreshing your memory. Fair to say that 3 USC section 9 creates the certificate of votes.
Yeah.
And the electors are to make 6 certificates of votes cast by them, right? Is that fair?
Yeah.
There's 2 distinct lists. One is president, the other one's vice president, right?
Yeah.
As an extra layer of protection, I get you don't understand belt and suspenders, but for protection purposes, the electors are to annex, meaning attach, correct? The certificate of ascertainment to their certificate of votes, correct?
That's how I understand this language.
So that is correct.
I believe so.
Yes.
I believe that's correct, as I interpret the statute.
Okay. So even though the governor may have a duty to transmit her, where it is, certificate of ascertainment directly to the president of the Senate, National Archives. The certificate of votes, notwithstanding that, must be attached to the certificate of votes, right?
I'm sorry, did you say the certificate of votes must be
Attached to the,
It says certificate of votes must be attached to certificate of votes.
I meant this, thank you for catching me. Certificate of ascertainment must be attached to the certificate of votes.
They're to be attached. Yes, I believe that's correct.
Okay. And that's part of the statutory process under the Electoral Count Act to assure the Vice President of the United States of America, the President of the US Senate, that he is in fact, or she is in fact counting and tallying the correct electoral votes, right?
I'm not sure the specific purpose, but the, I believe the purpose is to authenticate the documents that are, or to be able to authenticate the documents of interest.
Is it fair to, excuse me, is it fair to say that without the certificate of ascertainment, there'd be no way to know which certificate of votes would be counted under section 15 of the Electoral Count Act?
I'm not sure there'd be no way, but the way that the count, that the act provides is that the certificate of ascertainment be sent by the governor.
Would you agree with me that the certificate of ascertainment identifies the correct certificate of votes to count?
Yes.
I'd like to direct your attention to the certificate of votes in front of you. You have one that is from the 2016 presidential electors. Take a moment and review that if you could. Make sure you're looking at the right document.
Okay.
And that was to give or confirm, I should say, that Donald Trump and Mike Pence won the electoral vote, or their electors won the vote, I should say, in the 2016 Michigan presidential election.
That's correct.
And you'll recall, I'm sure, there was a lot of controversy around that election, right?
There was controversy.
Recounts and, standing for a recount, does all that ring a bell?
There was a recount that was begun. It was not completed, but yeah.
Why wasn't it completed?
I believe a court, I was not in my current position at that time, but what I remember is that a court stopped the recount essentially.
Director Grader, do you review binding law as it relates to Michigan elections prior to overseeing Michigan's elections, or do you just proceed? Let me rephrase. I understand that's correct. If binding authority comes out and says recounts require these things to be true in order for you to proceed, you would be aware of that before going into the next presidential election as director of the Bureau of Elections. Is that fair?
I would review the applicable statutes and relevant court decisions, yeah.
So with the 2020 election or certificate of votes, take a moment, make sure you're looking at the right document.
Okay.
It's very glaring attributes, those documents. Would you agree? Blue border.
I was trying to understand what you meant by glaring. They're distinctive documents.
Yeah. Blue border. Correct?
Yes.
Kind of fancy looking, would you agree?
Yes.
Something you can hang on a wall.
It is it contains a fair amount of artifice.
And again, those are copies of those documents. I presume you would agree with me that the originals are even more formal than that. Would you agree?
I imagine they'd be more visually impressive.
Right? Well, you reviewed it before sending it, correct?
I saw the original version of this document.
And in your opinion, your impression of reading those documents, were they visually impressive?
They were certainly distinctive. I don't know if impressive is the word that I would use, but they were distinctive documents.
Didn't you just use that word or am I making that up?
I don't remember if I said impressive.
I'd like you to turn to Exhibit 7 and thumb through that, please.
Okay.
Is that document visually impressive?
It certainly looks different from the other two documents. It doesn't have a border on it. I think that was one of the features that you referenced. There's no blue border.
One thing I do want to point out, I think you'll agree with me, is the entire document, both 16 and 20, is it's all completed on one page, right?
Yeah.
Fair to assume? Well, I don't want to assume. Let's say this, in your opinion, if someone's signing this document or this document, they would be viewing the entire document in its entire, in its completion at the time of signing. Is that fair?
I would expect that, yes.
Okay. With the Exhibit 7, it's a multi-page document, isn't it?
Yeah.
And in fact, I think you testified earlier, the signature page just has a statement up at the top of it that says, basically, we were here. Is that fair?
It says in witness whereof. We, the undersigned, have herein to, etc. So
sure,
that's what it says.
No page number?
No page number.
Nothing indicating that that would be affixed to multi-page document?
I couldn't determine that just by looking at this page.
If you were signing that page after viewing the exhibit as the Director, Bureau of Elections, comparing it with official certificate of votes, if you were not your specialized knowledge and experience, if you were signing that document, would you come to the conclusion that it would be affixed to a multi-page document?
I'm not sure I understand the question. It sounds like speculation.
He can give his opinion under 702, Your Honor.
His opinion as he was signing this particular document.
If he would come to the conclusion that that was going to be affixed just based on the face of the document, if he would come to the conclusion that was going to be attached to, affixed to multi-page documents.
I don't think that requires an opinion.
Well, I think he wants to know if this witness would sign that, or would this witness assume or draw the conclusion that it should be fixed to a multi.
And that, Your Honor, is just the signature page of Exhibit 7, where there's 16 signatures or peers.
I don't think that causes for speculation, because he's asking this witness to talk about what he would do in this situation. Am I
It's his opinion.
categorizing?
Yes, Your Honor, sorry. Yes, you are correct in my perspective.
I think that's still speculation.
Well, he's looking at the document. How is it speculative?
What he would do if he were being asked to sign that document is speculation, if just that page. I mean, that's a
I
circumstance.
think that's the question. If you would just receive that page,
right?
How is that speculation?
Well, gotta reword now. I don't, in the grand scheme of things, I'm gonna object to relevance, because what he would do isn't relevant to why we're here. It's about what these defendants are alleged to have done. So what he would have done has no bearing over what the defendants would have done.
You want to respond to the relevance objection?
I'll respond, and I think Ms. Shardy wants to respond too, but it's 702 opinion of a lay witness, Your Honor. He hasn't been qualified as an expert. He's viewing an exhibit that's in evidence. The Attorney General put it into evidence. He's got personal knowledge and experience that he can apply, in his opinion, to the signature page of Exhibit 7. It's perfectly permissible, and I'll leave.
And whether or not he would have believed that was going to be affixed to another set of
Yeah,
documents.
in reviewing just the one page signature, the signature page of this document, if he, in his opinion, would have come to the conclusion that it would be attached to a multi-page document.
Yeah, Your Honor, may I respond to that? Before
Yes.
Ms. Shirley? Michigan Rule of Evidence 702 requires that the witness have expertise or additional education or acumen for if something that a layperson would not know before they're allowed to render their opinion. Whether or not this witness would sign this document does not require an expert or a lay opinion, because it's not about whether or not this witness would have signed the document. It's about whether or not these defendants signed the document.
Can I correct something, Your Honor? I believe it's, I don't have the rules of evidence in front of me. I think the prosecutor's correct. I think it's 701 is what I'm referencing. And sorry, no, it was a good catch. So it is permissible, Your Honor, he can give his opinion. There's a foundation for it. It's crucial to the case. And I would ask the court to direct him to give his opinion.
Council Chartier?
Thank you. I join in what Mr. Coger has argued, but also he's the director of elections. He's being put forth by the government with his knowledge of elections. If he is looking at that document and there's no indication that it references a certificate of votes, if he wouldn't know that from looking at it, how on earth would a lay person know that? So I think this line of questioning is extremely relevant in terms of the intent of the individuals who are purported to have signed this and who are now facing 8 serious felonies.
I think it would be speculative for him to try to answer as to what he believed their intent was. I think he can respond looking at this, especially since he testified multiple times that he received this and he found it to be an unusual document, as to whether or not if he saw this document, would this give him reason to believe that this would be affixed to another set of documents.
Well, Your Honor, I believe the question is if the witness just saw the signature page alone, would he have believed that this was meant to be affixed to another document? The problem is this witness didn't receive just a signature page.
That's not the question before him, right? And you can always redirect him on that.
Well, that's why I've objected, Your Honor, because those aren't the circumstances in which the witness received the document.
Correct, and he's not asking that. So that's not really a germane objection right now. If you want to redirect your witness on that at that time appropriate for redirecting, that's fine. As it relates to him answering this question, I do believe that it's relevant, and I don't believe that it causes him to have to be speculative. So I'm going to allow him to answer the question.
Thank you, Your Honor.
So in my opinion, if I were looking at this page, I would expect that it was referring to something else, because it says witness whereof. So that would be, I would expect it to refer to something else that I was signing. Looking at this page.
Okay. And you may not be aware, but I will represent to you that the certificate of votes are also publicly accessible on the National Archives website. Any reason to disagree?
No.
The official, take a minute to refresh your recollection with the certificate of votes vote 2016 and the 2020 versions. They use the language, I'm quoting, elected in the general election. Would you agree?
Yes.
And it's got the blue border, which I would say jumps out at you, but if you disagree, please tell me.
That's fair characterization.
It also bears the state seal.
Yes.
And Director Brader, you would agree that the Secretary of State is the keeper of the state seal?
Of the Great Seal, yeah.
Turn to Exhibit 7 again, please. Where, take your time. I know. Second page. I know I'm asking you to scramble to read stuff, so not in a hurry. But where on that document that you're looking at, does it say elected in the general election?
I don't see that very well here.
Fair to say it doesn't say it?
Yes.
Where on that document is the obnoxious blue border that's reflected in the 2016 and 2020?
There's no blue border on this document.
Where on that document is there something purporting to be, I said the state seal, you said the great seal. So where on that document is there something purporting to be that seal or those seals or any seal?
No seal, no state seal of Michigan appears in this document.
There's a built-in requirement in 3 USC section 6. We've already looked at it. It might still be in front of you. If not, we can revisit it. Where successful challenges that would change the certificate of ascertainment. You'd agree with me that the governor is required to send a new certificate of ascertainment to Congress if the original certification or official nature of a certificate of ascertainment is changed. Would you agree?
I believe the act refers to a final determination through the appropriate legal process. I don't remember specifically what is required of the governor in that instance.
You would agree with me that though the Electoral Count Act contemplates the possibility that a certificate of ascertainment can change, correct?
I believe that's correct.
And in the event a certificate of ascertainment or the results of an election were to change, it would then be incumbent on the governor to create and transmit a new certificate of ascertainment, correct?
I don't recall the exact statutory requirement, but that's my understanding of the process in that instance.
And that, I believe you previously testified, correct me if I'm wrong, that would be to correctly identify which certificate of votes should be counted by the President of the Senate and the Vice President of the United States in the joint session of Congress, correct?
I believe the purpose is to authenticate the certificate of votes.
And I'll represent to you that 3 USC section 5 identifies reasons where challenges could be successful, or I should say categories of challenges that could be successful. I can show you the statute to refresh your recollection if you'd like, but I'm quoting judicial or other methods or procedures. Are you familiar with that language?
Generally speaking, I'm familiar with that language. I don't remember the exact language.
You don't recall that specific language, is that what you're saying?
Not literally, but I'm generally familiar with the language it describes.
You want to see it? Would it help to refresh your recollection?
Section 5. Here it is. Just to refresh your recollection.
Okay.
Earlier, I believe your testimony was that the only mechanism through which a certificate of votes could change was a judicial ruling from a court, correct?
That's the only procedure I'm aware of under state law.
I didn't ask you that. I asked you if you recall testifying that only a judicial opinion or decision could change the outcome of a certificate of votes.
I don't know whether I said that exactly, but I do agree that under my understanding in Michigan, once a certificate of votes has been completed, the only method that could be changed would be through a judicial determination.
Okay, fair. You would agree with me, though, that this section, 3 USC section 5, contemplates and opens up other methods or procedures under federal law, right?
Yes.
And fair to say that other methods or procedures could include the objection process we spoke about earlier, where it required one senator, one representative. Fair?
I don't know the answer to that.
The director of the Bureau of Elections overseeing presidential elections, and you don't know the answer to that.
I don't know whether one section of a federal law and stating other methods or procedures would include a type of objection raised in another section of federal law.
Are you overseeing the 2024 presidential election as Bureau of Director of Bureau of Elections?
Objection, relevance, Your Honor.
What's the relevance?
Relevance is I'll withdraw the question, but I want to know what preparation goes into getting ready for these types of elections when you're in charge of carrying them out, overseeing them, taking action to make sure the law is followed, that, you know, everything is.
That question may be relevant, but the question you asked was not, so objection sustained.
Thank you. A certificate of votes and a certificate of ascertainment. Let me back up. 2 certificate of votes being sent to the joint session of Congress or to Congress in general has happened before. You're aware of that.
I believe that has happened before.
So what we've been talking about is not theoretical. There's precedent for it, fair?
There's precedent for multiple certificates of votes to be sent from one state. Is that what you're asking?
Yes.
Yes.
And I believe my colleague touched on this, but I want to go into it a little deeper. You're aware that during the 1960 presidential election for the state of Hawaii, Republican Richard Nixon initially was declared the winner of that election, right?
I'm aware of a dispute in Hawaii in 1960, but I don't recall the specific sequence of events.
Director Brader, is it fair to say that when you received these documents or this document via email and you reported, took it to, I know you don't, made a phone call to, however you transmitted the information to the Attorney General's office, you were unaware of the federal precedent coming out of Hawaii in 1960 that this had happened before? Is that fair?
I don't know whether at that time I was aware of the incident in Hawaii in 1960.
Are you aware of it now?
Generally, yes.
Did you review documents in preparation of your testimony?
Yes.
What'd you review?
I reviewed the Michigan election law. And I reviewed the Board of State Canvassers document, canvas certification document. I reviewed the certificate of votes and the certificate of ascertainment in 2020. And I reviewed the certificates that the electors received from the Secretary of State. And I reviewed the email that was sent from the National Archives.
Did you review the controlling law on these matters or no?
I reviewed the Michigan election law.
You didn't review the federal law that controls the presidential election?
I did not review I did not review the Electoral Count Act specifically for this matter.
I'll represent to you, and if you have a reason to disagree with me, please feel free. I'll represent to you that in the initial outcome of the 1960 presidential election was conducted in the state of Hawaii, Republican.
I'm gonna object to the relevance of this, especially with this witness. And I would ask that counsel frame his remarks as questions to the witness.
There's some bit narrative there. What is the relevance first?
The relevance is that there's federal precedent for this. The Attorney General herself, I believe, is on record dismissing the historical precedent that would have been carried out here. As Director of the Bureau of Elections, he should be aware of the precedent for what he reported as, suspect or unusual to the Attorney General. To the extent I need to rephrase, Your Honor, I'm happy to rephrase the question.
We're also talking about this Hawaii case.
Yep.
We can move on. He's already told you he's only marginally aware of that case.
Thank you, Your Honor. Mr. Grader, are you aware whether any electors, Democrat or Republican, were charged with crimes in 1960 Hawaii as it relates to the certificate of votes?
Objection, relevance.
It's irrelevant.
Again, Your Honor, it's federal precedent that the government or the state of Michigan should be aware that what is alleged to have been carried out here is not a crime. There's federal precedent for it. If he's not aware, he just said he's not aware, and I'll accept that answer and move on.
Well, I'm trying to figure out why would that be relevant to it being a charge brought in 2023 for something that happened in 2020, because it didn't happen in 1969.
1960, it's relevant, Your Honor, because there's precedent for this. They're charged with quote unquote forgery, election law forgery, and documents that very, very closely resemble the 1960 Hawaii happenings are, basically mirror what my client is being accused of participating in a criminal nature. It's absolutely relevant. Federal law, frankly, trumps the state law. If the director of the Bureau of Elections is unfamiliar with federal law that controls Michigan's presidential election, that's good to know, but it doesn't make it irrelevant.
Council.
Federal law is inextricably intertwined with the allegations made by the government. While this is a state court, what their intent was and what other people may believe when looking at those documents and what those documents were purported to be is absolutely relevant to the charges against the individuals accused.
This question was, is he aware that there was no one charged in 1960?
Yes, sir.
Okay.
For doing substantially similar acts.
Why is that relevant? Why is this relevant for this?
I just asked if he was aware of it.
I'm almost certain that he's not aware of anything that happened as it relates to the Hawaii case at all, because that's how he's answered all the questions. So that's why I actually move on, because going by this one by one is only reassuring that he does not, he's less than marginally aware of what happened in that case. Is that accurate, sir?
Yes, Your Honor.
Thank you.
Thank you, Your Honor. We'll get to Michigan law. Oh, I'm sorry.
You had an objection to
I do,
join?
Your Honor. George Brown from Marianne Henry. For one thing, I think he testified that he knew something about the 1960s.
Well, we just clarified that he doesn't, because he's less than marginally aware of the question I asked him.
Also, I do believe, and the court did rule, that these questions do go to the witness's credibility.
I agree they go to his credibility, which is why I just clarified the question by asking him, was he less than marginally aware? Because I don't, based on his answers on these questions, I don't think he's aware at all.
Thank you. Director Brader, I'd like to talk about Michigan law governing a presidential election. You would agree with me that neither the Michigan Constitution nor a Michigan statute creates the office of the President of the United States or the Vice President of the United States, right?
That's correct. Neither creates the office.
You'd also agree with me that no Michigan law parallels the Electoral Count Act of 1887, correct?
I would agree with that.
Would you agree that no Michigan law informs as to how presidential electors are to be tallied, correct? Specifically for the Electoral College. I'm asking you.
How the electoral votes themselves should be tallied? No, I'm not aware of any provisions that govern that.
You'd agree with me that there are no statutory provisions nor any statutory authority in the Michigan election law. And when I say the Michigan election law, I'm referring to MCL 168.1 that's set that mandates a certificate of votes for the presidential election. Right?
I'm not aware of a section of the election law that uses that phrase.
Fair to say that the phrase excuse me, strike that. Is it fair to say that the Michigan election law does not include a provision requiring a document referred to as a certificate of votes?
I'm not aware of a provision of the Michigan election law that specifically requires a document called a certificate of votes.
However, the certificate of votes is required under federal law, as we previously established, correct?
Yeah.
I want to talk about election law forgery. As Director of the Bureau of Elections, you have familiarity with the crime election law forgery. Is that fair?
Yeah.
Would you agree with me that it's part of your job as director to work to ensure that elections are secure, of which alleged or suspected forgery is of crucial importance? Would you agree with that?
I would agree that identifying forged documents or possible forged documents would be relevant to ensuring election security.
And earlier you testified that you reviewed the Michigan election law prior to your testimony. Fair?
Yes.
And included in the Michigan election law is the statute that outlines election law forgery. It is 168.933A. Would you agree with me?
I don't remember the exact section number, but I agree that it exists.
I can refresh your memory. Yeah. Just to refresh your recollection.
Okay.
Now, did that refresh your recollection?
Yes.
You'd agree with me that the Michigan election law forgery statute is MCL 168.933A, correct?
Yes.
Now, under the Michigan election or election law forgery, there's two scenarios. Would you agree with me that constitute election law forgery? Is that fair?
Yes.
First being knowingly makes, files, or otherwise publishes a false document with the intent of defraud, correct?
Yes.
The second is knowingly makes, files, or otherwise publishes a document that contains a false signature or contains false signatures with the intent of defraud, fair?
Correct.
Now, section 2 is referencing something, a scenario where signature petitions, would you agree?
Subsection B would as I understand it, that could include signature petitions. Could include other documents as well.
Just give me a brief, based on your experience, what that means, signature petitions on a document. What is that?
Well, there's a variety of documents that someone might file that have signatures on them. Most commonly, candidates who are running for certain offices need to submit nominating petitions that contain the requisite number of signatures. There are other types of petitions as well, including initiated laws, proposed initiated laws, proposed constitutional amendments, referenda that would also require signatures. There's several others. So those, in my opinion, would be documents that contain signatures.
You've had personal experience with that, with the 2022 signature petition issues going around with gubernatorial candidates. Do you recall that?
Objection relevance.
Goes to his experience within the statute that my client's charged under, Your Honor. He's, again, executive officer, Bureau of Elections. Part of his duties, as I believe he testified, is to keep an eye out for violations under this Michigan election law.
Anybody else joining in this objection? Okay. I'll allow it. You can answer. Objections overruled.
Thank you.
Yes, I remember this issue occurred in 2022.
Here, though, we're talking about the first scenario. Knowingly makes, files, or otherwise publishes a false document with the intent of fraud, correct? As you understand the facts.
I don't think this witness has the personal knowledge to say what elements exist in this case? All he knows is he received a document and he forwarded for investigation.
Well, he forwarded it for investigation as he testified because he thought it was suspicious, Your Honor.
He said unusual.
Unusual. I'll use that word because it was unusual. You don't send it to one of the highest ranking law enforcement officials for the state of Michigan, who would present or prosecute something as a crime if you don't have suspicion that it is criminal.
Well, that's why he sent it to the civil litigations department, not the criminal section.
Well, that's true, but the Heather Mindgas operates as an assistant attorney general, and as an assistant attorney general, one wields all of the authority of the attorney general of the state of Michigan by statute. I believe it's 14.28.
And my guess is over civil litigation, and particularly only election law.
I'll move on, Your Honor.
Thank you.
You'd agree with me, Director Brader, that nowhere in the Michigan election law is the certificate of votes described.
I believe that's correct.
Again, not to beat the horse, but where it is described is in 3 U.S.C. Section 9, as we went over earlier. Would you agree?
I do agree.
And at the time, I believe you testified earlier that at the time, all of this was going on, this being the controversy over the 2020 presidential election. It was pretty much common knowledge that the Trump campaign, Republicans, the sitting president of the United States at the time, were all alleging fraud in Michigan's election. Is that fair? And again, not suggesting you agree there was fraud, just that it was very common knowledge that that was being raised. Is that fair?
I think it's fair to say that then President Trump and some Republicans are making that claim.
Very publicly, right?
Yes.
All kinds of news, interviews, so on and so forth.
Yes.
You're also aware that Michigan was one of 7 states being alleged to have mass fraud in their elections. Are you aware of that?
I don't know that I would limit it to 7. Based on my memory, there were claims being made all over the country. But I'm certainly aware that Michigan was one of the most high-profile states in this regard.
Director Brader, you would agree with me that if someone wanted to defraud the Vice President of the United States, President of the Senate, and cause them to count the wrong certificate of votes, they would necessarily need to affix a corresponding certificate of ascertainment to the certificate of votes. Is that correct?
I don't know what would be necessary to do something like that.
Well, we went over in great detail the requirement that the certificate of ascertainment is affixed, annexed to the certificate of ascertainment, and I'm sorry, the certificate of ascertainment is affixed to the certificate of votes. Do you recall that testimony?
Yes.
I said belt and suspenders, and you said you didn't know what that means. Then you agreed that the counted certificate of votes required the certificate of ascertainment to be attached to it. You recall that testimony?
Yes.
Is it your testimony now the same that if someone were going to try to entice the Vice President of the United States to count a particular certificate of votes, they would necessarily need to attach the certificate of ascertainment to the certificate of votes?
I agree that to comply with the federal statutory requirements, that the vice president would need to have those documents. Your question is what someone would need to do to successfully perpetrate fraud. And I can't answer that question. I don't know.
I didn't say anything about perpetrating fraud. I asked, I didn't.
Your first question, you did.
Oh, was it? Well, I'll rephrase. I'm not asking about fraud. I'm asking you, in order for the Vice President of the United States to count a particular certificate of votes, it must be accompanied by a certificate of ascertainment. Is that correct?
Yeah, and I believe that's been asked and answered several times.
It has been asked and answered, so we can move on.
Director Brader, you earlier testified that there were pending lawsuits after December 14th, 2020, correct?
Yes.
You knew about those lawsuits?
Yes.
And by the official count at the time, President Biden won the popular vote by approximately 154,000 votes. Is that fair?
Yes.
If you assume a hypothetical based on your testimony and experience that votes were switched after the safe harbor deadline that you testified to when my colleague was asking you questions, if you assume that the votes switched by 500,000 votes, Trump would have been ahead, right?
Objection, speculation.
It goes to the very real possibility that had votes been identified as problematic, unlawful, fraudulent, whatever, that if in a new count or the new official count, the vote could have swung back the other way.
And
That's-
also assume facts, not in evidence.
It's just a hype. And we're talking about,
So
we're talking,
you're asking to speculate?
no, well, I can move on.
Thank you.
Yeah.
Counsel?
Your Honor, George Brown from Marianne Henry. He did testify that he knows how presidential elections work. This is something that would obviously potentially happen during a presidential
Let's withdraw on
election.
the question.
If something occurred after December 15th, 2020, that would have required a new certificate of ascertainment, Governor Whitmer would have had to issue such a new certificate of ascertainment, correct?
I believe if a court ordered her to do that, then she would have to do it.
Well, it's not just a court. We went over earlier, it could be by other procedures, right, under the federal law.
Yeah, again, I can't speak to what would count as a valid procedure under federal law. The only one I'm aware of under state law would be court actions. But if she were legally mandated by an appropriate authority to issue another certificate of ascertainment, then she would have to do it.
Fair. It would be her duty to comply with the law, whether it's judicial or congressional or whatever, right?
Assuming it's a lawful order, then yes.
And had an alternate slate of electors not voted on December 14th, 2020, the state of Michigan's electoral votes would have been lost in the event that it got put back to the presumed loser of the election, correct?
I'm not sure how that situation would be handled.
I'll be pretty honest. Thank you.
So Bernard, you're going to cross examine?
No, my questions have been ably answered by my very colleagues.
We're going to be in recess for 1 hour. And then there'll be a redirect.
I'm sorry, what time are we coming back?
We're gonna come back in 1 hour, so 2:35.
Thank you.
You're welcome.